Maintenance matter. NBW has been issued against the petitioner. 24 minutes.
If you don't pay,
Trust matter, my lord.
24 matter has never covered up till now. Look at it.
There it was posted.
What is the status of it? Find out and post.
And
Yes.
I will come tomorrow.
Stage and
Right. Case is on Saturday, my lord, before the trial.
What we can do?
NBW
Yes.
is
My lord, there
suffering
is
from
a
kidney
urgency, my lord. The petitioner has lost the job. The interim petition, IA is pending for a consideration of interim IA, my lord. So kindly have it on 1st of July, my lord. The
Here
petition
is the petition.
23, my lord. From
Why should we have it on 1st of?
any date, my lord. Any date which is lordship.
Take it sometime. Yes.
My lord, it's an urgency, my lord. She has lost the job. I'm only getting a 10,000 of maintenance, and the son is getting.
Give the memo. Yes.
Respondent wife has filed 2 petitions in different maintenance, 2 maintenance orders passed by the family court. This honorable court has given stay order for 1 WP and another one there is no stay order. But still, although stay order is there, the family court is conducting the case, Mysore, my lord. So
It will conduct the case. Stay is with regard to that payment.
Yes, my lord.
But not about the main case.
Yes, my lord, because in another one there is no stay order also.
No, your problem is family court is going ahead. Family court is going ahead with the matter. This court will never stall the MC proceedings.
Yes, my lord.
It will go on.
No, it will go. But
As far as order of maintenance is only concerned, is state.
yes, my lord, because they are conducting the case and the case is pending here. They already filed the wakalat. They are on record, my lord.
We'll see. We'll see. No, we'll see. Yes.
Serial number 29. We are praying.
Out of the list. Out of the list. Any other mentions? Yes, call the list.
List number 1 for being spoken to, serial number 1.
No. Any adjournments they want.
Page adjournments. Page 1, serial number 82, serial number 5.
Serial number 19, my lord.
Page wise adjournment. Page number 3, serial number 6 to 8. Page number 4, serial number 9 to 16. Page 5, 17 to 19.
Serial number 19,
my lord. Serial number 18, my lord. 2 weeks time, my lord. Due to personal income is not.
Have you informed the other side?
Yes, madam. He is also present here.
At request of non-counsel, the petition list this matter after 2 weeks. Give a date. Yes.
Serial number 19, my lord. I have got a response in this case, my lord. Kindly grant 2 weeks time, my lord. The negotiation is going on, my lord.
Have you informed the other side?
Yes, my lord. Kindly have this on 8th or 10th.
Non-counsel appearing with the respondent submits that negotiations are going on, hence request for time. It is submitted that it's already informed to the other side. List after 2 weeks.
My lord, 8th or 10th of July, my lord.
Yes, 10th of July. Yes.
Page number 6, serial number 20 to 28.
My lord, serial number 24, my lord. Day before yesterday, my lord, is served the copy mail objection, my lords. Kindly grant 1 week time, my lord, for filing the rejoinder because so many allegations against the wife, my lord, even the character assertion also, my lord, is required to file a
Have you informed the other side?
Yes, already informed, my lord.
I appear for the respondent. Kindly have it on 7th or 9th, my lord.
List this matter on 8th of.
My lord, only one submission, my lord. Kindly grant extended the interim order.
8th, at the request of non-counsel, the petitioner. This is a matter on 9th July. Interim order already granted is extended till then.
Great. Much
Yes.
obliged.
Serial number 20, my lordship.
20.
20. Serial number 20. Kindly praise 2 weeks time, my lord. Idal criminal mesili lawyer record kelidive. Henceforth we need
You're appearing for whom?
for respondent, your lordship.
Who moved the memo?
I'm not.
They have moved the memo. Have you informed them?
No, ma'am.
Wait for your turn. Yes.
Page number 7, serial number 29, 30.
20? That's the matter at the request of both the councils on 15th of July.
For being spoken to, serial number 1, H.V. Bhanu Prakash for petitioner. P.C. Shivanegowda.
Yes, what is it?
Really, statutory amount 25,000 may be transferred to trial court or permit with it. That's one.
Okay. There is an order. only that is not there, that
That is
amount
not-
in deposit.
Yes, 25,000 charge amount.
Amount in deposit shall be forthwith transferred to the tribunal. Yes,
Withdraw the appellant. Withdraw, permit to withdraw the amount.
ಇಲ್ಲಿ ಕೊಡಕ್ ಬರಲ್ಲ.
ಅಲ್ಲ ಟ್ರಯಲ್.
that is, appeal
But
is
ಅಲ್ಲಿ you have to
allowed.
file application.
Who will withdraw? Whose appeal is that?
Owner appeal. It's a owner appeal. Liability fixed on the insurance
So
company.
in the light of the other order passed in the other case, it is allowed.
Yes.
It's a owner's appeal. The amount in deposit, the charge. He can only withdraw and the amount in deposit shall be transferred to the tribunal and the owner is at liberty to withdraw the same.
Number 2, PC
Please.
Shivanya Gowda.
But in this case,
Huh.
point is, my lord, the disable court has hold that, my lord, our contention has been rejected. And consider that, my lord, the injured person was an employee of the insured. Why, I have addressed the argument, if liability against the insurance company, considering that he is a cleaner of the insured vehicle, my liability is limited to under the WC Act, not under the motor policy.
That is not clarified.
That is not what's clarified in there. If that is calculated, my lord,
Appeal of the appellant insurance company is partly allowed.
please.
Then-
But my liability is limited to, in terms of WC Act, that was not calculated. My lord, in this case, my lord, court has taken the income and the
It
compensation.
needs to be heard then. No, because we can't clarify all that in a being spoken to. File a review.
Please,
File it immediately, it will be listed.
I will.
CL number 3 for dismissal.
Just give it.
Yes, ma'am. And for the petitioner, the respondent supposed to have filed their memo of calculation as to what amount they received. So copy may
Give
be,
him a copy. Yes, please.
I will look into and discuss and come back to your lordship.
Memo of calculation.
Yes,
Is
ma'am.
filed with an accounts for the respondent. This is matter on Tuesday.
Please.
Yes, next. Delete from the caption dismissal.
CL
Yes.
number 4.
I appear for the petitioner, my lord.
Appear for respondent.
Petitioner husband, the challenge is under 125, where it had reached finality. While admitting this case, this honorable court had directed me to deposit, pay a sum of rupees 25,000, including both of them. Up to last month, I have paid, my lord. And I'm filing a memo. And one more submission, my lords.
It is a submission of the land council for the petitioner that except for the month of June, the petitioner had paid all the amounts as per the order
Yes, ma'am.
passed with the court. As per his instruction, the petitioner was regular in paying the amounts and will come up with specific instructions with regard to the payments.
Yes, ma'am. I have received the payments
That
until
he
last.
has,
Yes, ma'am.
till now
Until
he has
last.
paid.
He is paid. 25,000, yes. Ma'am.
Along with this memo, my lords, the subsequent development after filing of this petition is the pending divorce petition was allowed in Pune in favor of the petitioner husband. And the
Different element is paid.
maintenance, because she had abandoned him. So on that ground, maintenance was not given, and she had adduced evidence that she had admitted on record that she is employed. So therefore, considering that, there is a specific order. Subsequently, my lord, she had also filed a domestic violence case before Mangalore court, my lord. And that was also partly allowed. It was a clear finding that there was no domestic violence. But only certain amounts were ordered, for which that has been challenged.
It's in criminal miscellaneous 46 of 2018, which is
No,
under challenge.
In the
ma'am.
light of the order that is passed by the court in the MC,
Yes,
that there is on the ground of desertion, the divorce is granted.
yes.
When you have deserted the husband, how you are entitled for
Well, it's-
the maintenance is the question now.
That is the finding in the MC
That
petition.
that finding will be considered even if you
It-
file
it
the
is
other
the-
case also.
Yes, ma'am.
Because it is it's a suit where a full-fledged trial is conducted, not
Yes,
like
ma'am.
125 CRPC.
Whereas Malots, in the first place, I have not deserted Malots, even I was ready to go back. That finding itself is not there, Malots.
Have you
He
questioned
files-
that order?
That order has not been challenged before
When
the
was that order?
That order is, my lord, dated
30th January 2024. Malots.
30th January
Then that
24.
means you have not decided to, then on that ground, why this RPFC should not be dismissed?
No, unfortunately,
Allowed.
Malots, that MC petition is filed before Pune court, Pune family
Whatever
court.
it is,
Well,
that
they
is
are
between
not,
the same parties.
she resides in Bangalore, my lord, she is not able
She
to
didn't
go.
contest it.
No, she contested.
She is not able to go to the Bombay High Court, my lord. She filed
Once that findings are there on record, then under 125, how are you entitled for maintenance?
No, my lords, what has happened is the family court in Pune has made a finding that the maintenance is being paid in view of the order of the Mangalore family court, my lords. And due to that, there is no order with regards to the maintenance to the wife. To the daughter, there is an
One
advancement.
aspect, that is one aspect.
Yes.
Now, when there is a finding by the court that you have deserted the husband without a reasonable cause.
My lords.
Without a reasonable cause, you are staying away from the husband. In the light of that finding, are you entitled for maintenance under 125?
No, my lords, in the first place, he files a petition for divorce, my lord. He doesn't try to reconcile with me itself. That finding is there.
List this matter after 4 weeks.
Please.
Delete from the caption dismissal. Yes.
Much.
Serial number 5. Serial number 5.
For the petitioner in this matter,
Yes.
there are some office objections that respondent has to
Objections are
comply.
complied with. It was only as regards service of the statement of objections to them.
Non-compliance about the rectification of on the statement of objection.
I've,
That is served on.
it's served
on,
and we've been heard on that
Case
also.
of office objections on the IA filed by the council. That is other side service copy not. Yes. What is this?
My lord, the petitioner is the husband, my lord. The respondent files a petition seeking dissolution of marriage before the family court. The respondent, my lord, is a doctor by profession.
Come to the impugned order. Where is it?
Impugned order, your lordship will get it at running page number 24, my lord, of my petition.
What is this IA?
Now, my lord, I have filed an IA under Order 11, Rule 5, seeking for disclosure of the financial status which has been filed by the respondent before the DPAR. The respondent is a superintendent of police.
You're for the wife.
I'm for the husband, my lord.
Oh, wife is
I am a
working?
doctor. The husband is a superintendent of police. She files her assets and liabilities before the trial court. The trial court, the assets and liabilities that has been filed by the petitioner therein, my lord, is not in terms of the information that I've had. She is much more wealthier than what she has filed. So I sought for certain documents from the DPAR. That application came to be rejected. Thereafter, I filed this petition challenging the impugned order, my lord. There's an interim order of stay as of now of further proceedings. Now, my lord, there is no incumbency for the respondent herein to produce these documents. He's a public servant and those documents ought to be produced.
This court has granted stay.
Yes, please. My lord. That's a stay
Unfortunately,
before.
Coordinate.
please, my lords.
All that I'm seeking is, my lord, let her come out clean with her financial status because she has not submitted her 3-year bank statement before the trial court.
What is, let's come to your IA. Where is that application? Page number?
The application is not a part of the record, I presume, my lords.
How they have numbered it without an IA?
Now, my lord, kindly come to running page number 38, my lord. That is the IA which is in challenge. Annexure B.
Annual assets and liabilities statement furnished to the petitioner for the year. What is the wife?
She's
Then what respondent?
She's an ACP or deputy superintendent of police now, my lord. Now, my lord, if your lordship comes even to their objections, my lord, they admit that there is no qualms about her status in the police force, my lord. The impugned order, my lord,
1 minute, let me look at the affidavit. When is the IA filed for maintenance?
No IA filed for maintenance.
no IA has been
For
filed.
what this assets and liabilities then?
Kindly come to their petition, my lord. Memorandum of divorce petition at running page number 47. That's the reason there's an interim order. Kindly come to the prayer of the petition which is at running page number 67 and prayer number B, I may be permitted to read running page number 67, my lord. Also direct the respondent to pay a sum of rupees 1 crore to the petitioner as permanent alimony. She has made such a tall claim. Throughout the petition, she states that I have not paid any maintenance, I have not taken care of the wife, so on and so forth. Since there is this prayer B,
When the wife is asking for permanent alimony, what the court will look at?
the assets and liabilities, definitely, my lord. So that is the reason there is an interim order of this honorable court. In fact, I think senior
Assets and liabilities of whom?
of the here the respondent, there the petitioner, the wife. She is asking for alimony from
From
me.
the husband.
So we want to see
what
her
we have
financial
to-
status. We want
You want to see the financial status of the wife?
yes, that is all, my lord. And we are not sought for any document which will be incumbent upon the respondent
So
hearing to
which judgment says so? For granting permanent alimony, you should look at the financials and status of the wife.
of both the parties, my lord. Of both
Let's see the judgment where it says. Which judgment says so?
right now I do not have it, my lord, but both the financial status of both the parties has to be.
Stand for the interim maintenance or
Has
the
to be.
maintenance alimony she is seeking.
Now, my lord, in fact, there was a learned senior counsel was appeared before this honorable court. They came before this honorable court and even stated that they will modify the prayer B, that they will not claim for this permanent alimony at all.
Subject to, my lord, certain mutual considerations. They have not responded from their end. We are not going to press.
And
on that.
please come
That's
for
all.
your order. I know understood what is your.
My lords may kindly take page 28 of the petition, my lords.
Please read the order from paragraph number 6.
Well, it's paragraph number 6 is, my lords.
Let him read.
Obliged.
Yes.
Running page number 24 is the order.
Yes.
Now, my
Anything
lord,
you want to add?
please, my lord. Now,
Anything more you want to submit?
please, my lord. Running page number 30 and 31, my lord.
I've seen the entire order.
Yeah, the two reasons basically is, my lord, that she has also filed another assets and liabilities in one criminal miscellaneous in a domestic violence case. Running page number 31, it has been reasoned that as pointed out on behalf of the petitioner, this being the petition filed for dissolution of marriage, petitioner has not filed any application for claiming maintenance. Now, my lord, all that I am seeking is, if there is a remedy available for the respondent herein while she is seeking a high permanent alimony, my lord, if that prayer has to be done away with, then I will not have any claim before this court. I will withdraw the petition itself. Now, that prayer B is coming in my way, my lord. Now, what she says is that, my lord, in her assets and liabilities, she has stated that she does not have any personal assets. So there is some falsification on an oath that has been submitted by the respondent before the trial court.
What were you doing till her cross-examination is completed? And
No,
when
only one date, my lord, only one date. The moment I have received it.
she has filed this, whatever she sorted this 1 lakh, 1 crore rupees and all at the beginning. That is what is her case.
She had filed it at the beginning, my lord. But thereafter, my lord, during the course of cross-examination, after the assets and liabilities come to be filed by both the parties, I realized that there is a lot of falsification on the records. My lord. All that I'm seeking is let her come out clean and file whatever she's filed before the DPR. The reason of the trial court is that it's private information, which is aberration of law. That is not private information as regards matrimonial dispute. As regards any third person, yes, I do not have any right. If I were to be any XYZ, I cannot go and seek for the information of the employment status or the financial status of any government servant. But as regards the husband, being the husband, and when there is a tall claim of 1 crore rupees alimony which has been made against me, all that I'm saying is let her state what are the assets that she has acquired and what are the private properties that she has acquired, because all of that in those columns she has mentioned as not applicable or nil. This is my contention, my lord.
Please go. Agreed with her. Order passed on I number 6 in MC number 6839 of 2023, dated 27/2/2025. The husband is before this court. Wife had filed the MC seeking divorce and also sought for permanent alimony of an amount of rupees 1 crore. When the matter is sat down for the cross-examination, at that point of time, the husband had come up with the instant IA. That's I number 4. The prayer in the said IA is that to direct the Inspector General of Police or the Principal Secretary, DPAR, Vidhan Sauda, Bangalore, to produce the annual assess and liability statement filed by the wife. The reasons that are stated in the affidavit in support of the said IA is that the grounds used by the wife is far from the truth in her petitions, so that the averments have to be disproved by producing cogent evidence. As such, they have come up with the said application. It is also stated that before filing the application, the husband has approached the department and as they refused to give the same, it compelled him to come up with this application. The family court, by order impugned, had dismissed the IA number 4. While dismissing IA number 4, the court has observed that in the IA it is stated that the document is very much important to elicit the truthfulness of the case of the wife. Except this averment, nothing is made out in the affidavit filed in support of the application that why the documents are necessary. The matter is posted for cross-examination of PW1. Even at the time of arguments, it is submitted on behalf of the husband. It is not submitted why the documents are necessary. It will be made out in her cross-examination. The court has also observed that the wife had adduced her evidence on 24/6/2024, and with regard to the additional documents, as no objection is submitted, Exhibit P1 to P36A came to be marked on behalf of the wife. The matter is adjourned for the cross-examination from 27/2024, and as the husband had not opted to cross-examine PW1, even after imposing cost, it was taken as cross-examination not adduced on 16/12/2024 after granting 5 adjournments. Again, PW1 is recalled as per order dated to 17/1/2025. After recalling of the witness, the present application is filed, stating that assets and liabilities of the wife for the year 2017-18 to 23 to 24 is to be summoned either from the IGP or from the principal secretary. The court observes that the wife had not filed any application claiming maintenance. So her assets and liabilities, what she had filed before the department, is nothing to do with her contentions in the present case. Further, court also observes that the personal information that is given to the department cannot be sought by the husband in this application. Further, the wife has also filed all the her statements of assets in the DV case, which is pending. The court dismissed the application, finally observing that no valid grounds are made out for allowing the application, and that information is not necessary for deciding the present case. Agreed thereby, the husband is before this court. A coordinate bench of this court on 12/3/2025 had granted stay of all further proceedings in MC number 6839 of 2023, pending on the file of the 4th Additional Principal Judge Family Court, Bangalore. Land counsel appearing for the petitioner submits that when the wife is claiming 1 crore rupees as maintenance, it is necessary for the husband to establish that whatever the assets that the wife is having, which are not brought to the notice of the court, unless and until, and she has made so many false statements. There is a lot of suppression and also false statement before the court. Unless and until this application is allowed and the assets and liabilities that are filed before the department are called for, the husband would not be in a position to elicit the correct facts. Land counsel submits that the finding of the court that it amounts to personal information is also not correct, and the reasons on which the application is dismissed is without any basis, and the order needs to be set aside. Any other thing?
That's all.
Land counsel appearing for the respondent wife submits that the wife had not asked for any any maintenance, and for deciding the permanent alimony, what the wife is seeking, the assets and liabilities of the wife are not the consideration for the court, and the order passed by the court discloses that the husband had failed to cross-examine the wife, and the cross-examination was closed. Again, it is reopened, and she was called for and it was reopened. And after the same is reopened, they have come up with this application, which shows that only with an intention to drag on the proceedings, they are coming up with this application, which is irrelevant, and the findings of the court, and the court had passed a reasoned order considering all the aspects, and no interference is called for. Next one. Having heard the counsels on either side, there is the material on record. The MC is filed in the year 2023. In the MC, she has sought for the maintenance of an amount of rupees 1 crore, alimony of an amount of rupees 1 crore. According to when the wife seeks alimony of an amount of 1 crore, it is for her to establish before the court what is the financial capacity of the husband, and whether whether she is entitled for such an amount or not, basing on the facts and circumstances, the court will decide the same. The when and even that apart, when the matter is set for the evidence, when already so many opportunities are given to the wife, given to the husband to cross-examine the wife, the husband has chosen not to cross-examine and sought time, and the same was closed. And thereafter, at their request, the same was reopened, and at that point of time, again this application came to be filed. In the considered opinion of this court, the reasons that are stated in the application, the cannot be a ground to summon the particulars from the department. The court had rightly considered all the aspects and rightly held that the said documents are not necessary for deciding the issues between the parties. In the light of the above discussion, this court is of view that there are no reasons to interfere with the order passed by the court, accordingly dismissed.
May I make a request, my lords? May we complete the trial together in 3 months, my lords, if my,
Fourth additional court, they have lot of matters of 23.
very well.
One submission. May it also be observed that they filed their statement of objections. In that, my lord, from paragraph number F to paragraph
They have
number.
filed the statement of objections, which year? What is the date of statement of objections?
That is of the respondent, my lord. They filed it on. No date that they have mentioned. It is in their objection
So
statement.
been filed along with.
No, my lord. They have filed it subsequently. In that, categorically, only this observation.
You should have stated all that in your application. That the whole purpose
that
of
is-
filing an IA in support of any application.
That I have
affidavit
mentioned in
is-
my IA, my lord.
When-
Affidavit.
What did
So
you say
here
when they have
from-
filed?
One submission, my lord. From paragraph H to paragraph
That-
number K, everything is false, my lord.
No. In your affidavit, please come to the affidavit that is filed in support of the IA. Where did you say so? When was it filed? What is the relevancy? Why do you want? Nothing is stated. I've seen already the affidavit. Yes, next.
Affidavit is of 12th February, my lord.
Yes, next.
Hearing on interlocutory
So-
application, serial number 6.
Obliged.
Arti Somshekhaya.
Petitioner really challenges the granting of interim
Uh-huh.
maintenance. Petitioner filed this petition challenging the granting of interim maintenance. My lord, the Assam court my lord, directed me to deposit 50% of the amount. Accordingly, it is deposited. Thereafter, my lord, the parties have settled the dispute. She has withdrawn the main petition itself, my lord. Therefore, I have filed application to permit me to withdraw the amount which is deposited before the.
No, what is that memo? What are the conditions of that settlement or any withdrawal? Now, we have to look at that. Where is that order? How it is agreed between the parties with regard to the amount that is deposited here. That's why I wanted to hear the counsel for the respondent.
We have informed to telephonically also, my lord, but they have not come. Lordship may have it on Monday, my lord. If
Yes.
they didn't come, my lord,
Yes.
we'll have that.
Yes. Even on the last occasion and today also, there's no representation on behalf of the respondent. This is matter finally on Monday. Orders
Please.
will be passed.
Please.
Serial number 7. Rohan Kotare, a petitioner.
Your
Niti AM.
Ladyship's order dated 5/6 was taken up to the Supreme Court. On 25th,
Was dismissed,
the
my lord.
Supreme Court has dismissed the SLP, reaffirmed the order, and stated that on the 4th of July, 4/7 at 11 a.m., the concerned lady officer from the DCPO, Ms. Asha, has to collect the child. I'm placing on record a
Take that
copy of that order. My only request, Your Ladyship, is we were orally informed when we spoke to the DCPO officer as to what happened on the last occasion when you went to collect the child. She said,
One minute.
yes, Your Ladyship.
A reasoned order is supposed to be passed on that, to be followed.
No, it is still pending.
Yeah, yeah,
It will
yes.
be passed.
It will be passed.
So.
Your
now
Ladyship, what had
when is-
happened,
When they have to go to the.
4th of July,
4th of July.
I would only request, let this matter be taken up on 4th of July at 2:30. And in today's order, Your Ladyship, if I could request one observation to be made. On the last occasion, this Miss Asha from the DCPO had gone to the location where the child is residing, the society. What she informed us, and I'm told that she's submitted a report to this effect before the Honorable Court, is that the private security at the society prevented them from entering on instruction of the respondent mother. And when they sought, I'll just finish up. And when they sought to enter, because they had a lady constable along with them, they were intimidated. In fact, and I'm sorry to bring this up, counsel for the respondent has called them up, intimidated them, saying we will file a police complaint if you try any further to enter the campus. So I only want an observation to the effect.
Place it on record.
On
Even
affidavit,
placed on
my lord.
record. The DCPO's report is
My
placed
lord,
on record.
on affidavit, my lord, my submission would be,
No, I'll hear you. Let me look at it.
insofar as this submission, if it can be put on affidavit.
No, I'm.
Therefore,
looking at
because
the
allegation
DCP's
is also against me now.
Yes.
Yes.
DCPO report 16/6. It has been filed directly by
15?
16th of June, Your Ladyship.
Oh.
It's not been filed by us, it's been filed by.
Upon our arrival, Mrs. Amrita Sinha was uncooperative. Her counsel, Mr. Nitin, informed our office that neither the mother nor the child would accompany the officials, stating that the High Court order was not acceptable to them. Despite our officer's efforts to explain the necessity to comply with the court's directions, the respondent and her counsel refused cooperation, thereby obstructing the execution of the order. District Child Protection Officer.
On date, my lord?
Whatever is the date, can you?
No,
afford to
there
say
is
that?
my lord, one
It's on
second.
16/6.
16. My lord, what actually happened is this. On 15th, the child was supposed to be taken. On 16th, in fact, I have also contacted them and I have informed that the child is supposed to be taken. They stated that there was no direction to that effect that is received by them. That is why I said, let there be an affidavit on what has been
No,
stated.
we don't require any. affidavit
Insofar
now,
as on
because,
16th,
They have addressed it to the Registrar Judicial.
yes,
I will ask you to file an affidavit now.
I will definitely file. Insofar as
this
this
on
entire thing is on 16th,
On 16th, the Registrar, the District and Child Protection Officer, Bangalore West, District Child Protection Unit, Bangalore West, Anekal, has addressed a letter to the Registrar Judicial dated 16/6/2025, stating as below, extract the entire thing. Right from the beginning, this court has also observed that the counsel, being an officer of the court, at every time is not cooperating with the directions that are passed by the court. And at every stage, there is reluctance from not from the party, but not only from the party, but from the advocate, from understanding what the court is saying, which is in the interest of the party. And considering this letter that is addressed by the District Child Protection Officer, this is nothing but interfering with the administration of justice. The copy of this letter dated 16/6/2025 shall be given to the counsel appearing for the respondent, and the counsel shall file an affidavit and his response with regard to this particular statement, that this particular communication that is received from the District Child Protection Officer by 4th of July.
July.
Yes, and what is that other thing?
In the meanwhile, let it be recorded that on the morning of 4th of July, respondent shall comply with the order of the
Next,
Honorable Supreme
after
Court.
that, The next one, continuation. This court on
5/6.
on 5/6/2025 has passed an order directing that the District Child Protection Officer shall take the child on 15/6/2025 at 11:30 a.m. along with the mother to the Department of Child and Adolescent Psychiatry, NIMHANS, as per the report date. And as per the report dated 22/5/2025, evaluation shall be done and a report shall be placed before the court. This order is assigned before the Honorable Supreme Court by filing SLP number 17006 of 2025. That came to be dismissed by order dated 25/6/2025. Not dismissed, but that order Honorable Apex Court has passed an order that they're not inclined to entertain the special leave petition and accordingly dismissed. However, considering the subject matter, a reasoned order, what is this reasoned order should be passed? That
Reasoned order would be passed in
Passed by the
context of
Supreme
the
Court.
fact that your ladyship's findings are being reaffirmed.
That's what that will
That's
follow.
what
Not
that is the
about
reasoned
this
order,
court.
not
about
the
this
operative
That,
part.
however, considering the subject matter, a reasoned order should be passed. And the court observes that since the date of examination of the child by the Department of Child and Adolescent Psychiatry, NIMHANS, Bangalore, is on 15/6/2025, which has expired. They have directed the Honorable Apex Court has directed the District Child Protection Officer, Anekal Taluk, Bangalore, to take the child along with the mother, that is the petitioner, for examination to the Department of Child and Adolescent Psychiatry, NIMHANS, Bangalore on 4/7/2025. In the light of the order passed by the Apex Court and also the earlier communication that is received by the Registrar Judicial dated 16/6/2025 from the District Child Protection Officer, this court makes it very clear that as per the order of the Honorable Apex Court on 4/7/2025, the order has to be implemented. Any impediment and any obstruction in implementing the order of the court will be viewed very seriously. List this matter at 2:30 on 4th.
In the meantime, my lord, I have filed an application. In fact, one recall application was filed that does not survive anymore, that may be not pressed. So far as one more application that I had filed seeking for a direction to the registry to provide me the copies of the report that is filed by the doctor. If an order is made on that, I would receive the copies of the order, which I do not have.
I have no objection. Let him be provided.
Nobody can have any objection on that. The land counsel for the respondent seeks a report of the NIMHANS, which is placed before the court. Registrar Judicial is directed to give furnish a copy of the same to the counsel for the respondent.
In that, what has happened, my lord? One-page report was submitted. It was provided to me. The annexures along with it.
Along with the annexures.
Yes, much obliged.
May I request that I be permitted to carry out hand service of this order on the lady?
The counsel with the petition is permitted to take out hands, can have the hand summons of the hand delivery of the order.
I'm deeply
much obliged.
Cell number 8, for preliminary hearing, G. Balakrishnan Shastri for petitioner.
Yes.
Lady, IA 11 was, it's the husband's petition, my lord. IA was filed by the wife seeking custody of the daughter and then 15 lakh rupees towards the education.
No, yesterday why it is adjourned is court wanted to know.
Yes, my lord. The husband's salary and the specifications your lordship asked for.
Yes. The petition is directed to pay actual educational expense of both the children for from the academic year 2023 to 2024 till completion, apart from 15,000 interim maintenance. What is the salary of the husband?
2,15,000 per month.
2,15,000 is the salary. What is the salary of the wife?
My lord, it is over 1 lakh, but we are not sure because she is working in Mumbai.
Let's say 1 lakh.
Yes.
So now what are the expenses? Educational expenses. How much are they?
My lord, currently son is studying engineering first year. And daughter is 11 years old and in school, my lord. Now, our grievance is especially with respect to no direction or order with respect to the consent of the father or consultation with the father while getting the admission for the children. Just the decision-making power is given to the mother because both children are residing with the mother and the
Generally,
cost is
naturally-
being borne by the father. That is one thing, my lord. Now, if,
No, it is like this.
Yes, ma'am.
Now, first we'll look at the financial capacity of the husband, whether he is able to pay or not.
Yes.
Once he is able to pay, now all these things, we will decide it at a later point of time.
Yes, ma'am.
So we'll issue notice when you are capable of paying the maintenance and you have other issues to be sorted out. Then all those guidelines we will lay down, all those directions we will grant once the husband enters appearance.
Absolutely, my lord. No, not a
Notice.
problem. But my only request is kindly stay the order, which is.
That cannot be unless
No,
no,
my
you
lord.
show the reasons. it
The
can't be.
reason why we are seeking is
Yes.
it's an absolute order without any,
That's what, it will not take years together for the wife to come, notice to the respondent and the petitioner is
I may be permitted to
to
serve
take
it-
out hand summons on the council appearing for the respondent, but once the memo is filed, this meet.
I appear for petitioner.
Madam, in this case, matter was heard by your lordship yesterday.
Yes, yes.
Yeah, well, in this case, your lordship may recall, 2 writ petitions were filed by our client and your lordship had issued notice earlier and they have been served and they are also posted today.
Yes.
What I want to bring to your lordship notice, Madam, your lordship will kindly take.
What
the
we will do is,
request
no. What we will do is, now the impugned order is one and the same.
Please, my lord, please.
No, yeah, we have also challenged the same.
They are challenged the.
There are 2 writ petitions, one filed by them and one filed by us. Apart from that, my lord, I have filed a writ petition. Your lordship may kindly take 15,361. In that also, your lordship have issued notice.
What is that 15,000?
361. My lord, in that page 19, your lordship may kindly have a look, my lord, page 19. Impugned order. Respondent is hereby restrained from removing the minor son written from the territorial jurisdiction of Karnataka without prior permission. This is the order made, my lord. Now, how can I have the visitation rights, my lord, if she takes away anywhere in Karnataka? That is why your lordship will have to also decide. He can't take the child from the jurisdiction of Bangalore. Page 19, my lord. Operative portion.
Take the next one. What is that? What is your grievance in WP 14353?
Miller, 14353, same, Miller, my difficulty. The interest of the child of the welfare is important, Miller. Both of us have said, I have said modify the order suitable to welfare of the child. That is my prayer. In fact, Miller, all of us are interested in the welfare of the child. The child in this present case is suffering from a disease of kidney and the doctors have advised that every day the child has to be given the prescribed tablet. If it is not given, there is every possibility of one of the kidney being enlarged and resulting in this surgery. That is the importance, madam. That's why.
Senior counsel,
Why-
please come to
Yes,
the
madam.
order in 14353.
Yes, madam.
Please come to the order.
Yeah, yes, madam. I'll read that. Page 25.
Please come to the operative portion of the
Yes, madam.
order.
Yes, madam.
Yes.
First, person is entitled for interim custody of the minor child, rhythm between 2 p.m. to 6 p.m. on every Saturday and Sunday, and he shall pick the child from respondent's mother's house and drop him back. That's the first order. Second,
1 minute, pausing there. You have any difficulty with it? Do you have any difficulty with this part of the order?
no, my lord, I want to take the child. I am interested in taking the child.
Yes,
I have
yes.
no objection.
Then come to the next part.
Yes, ma'am. Persons also entitled for interim custody of the minor child rhythm on birthday of the child and during all festivals from morning time, and he shall pick the child from respondent mother's house and drop him back. No objection.
So you have no complaint on this
Yes.
also?
No.
What 1 minute? What about you? What about 1 and 2?
1 and 2, my lord. The father is entitled for interim custody on every weekends, my lord, because mother is deprived of spending time with the child on Saturday and Sunday weekends, my lord, because the respondent.
Is she working?
No, my lord. She is.
She's a housewife.
She is housewife.
Then what is the deprivation?
My lord.
The whole week the boy is with her.
Boy is with her, my lord. The reason is that, my lord, the respondent mother is ordinary resident of Hubli, my lord. Her parents are residing at Hubli, my lord. Now she has to take care of her child because she cannot alone travel to Hubli, my lord, because the child is aged about 2 years, 9 months, my lord. Because the child is also suffering from kidney related issues, she has to take care of
Where
the
is she
child.
residing?
At present, Bangalore itself, my lord.
Then
When she has to travel to Hubli, every weekend she cannot be resident in Bangalore itself, my lord, because he has to travel with her brother, my lord. Alternative, we have suggested that alternative weekends may be granted, my lord. In midweek, we will provide.
In that case, what you can do is when you are not in station, that should be compensated in the next week.
Please, we'll do that, my lord. We can do that, my lord.
Yes.
And
Then
this, my lord, second question.
next.
Please, my lord. The petitioner is also entitled for interim custody of the minor child, rhythm MS, on birthday of the child. Birthday, we'll provide the visitation.
So no
my lord.
difficulty
No
with that.
difficulty on
Now
birthday.
we'll go to, yes.
Please, my lord, please, my lord. I'll
Senior
continue.
counsel, next one.
My lord, please, my lord. And during all festivals, my lord, the phrase used is all festivals, my lord. The respondent, my lord, husband is under apprehension that he may claim on non-festivals as well, my lord, because on Ramzan, Christmas, and all those things.
Not all the parties are Hindus.
Please, my lord, they're Hindus.
All Hindu festivals.
That has to be modified, my lord. All festivals.
No objection, my lord.
By the family.
The phrase used that all
Then
festivals.
now, next one is petitioner has the right of contact with the minor child on alternative days through video call for a period of 1 hour in between 5 p.m. to 7 p.m. with prior intimation to the respondent.
This is causing very much.
Senior counsel.
Yes, madam. I am submitting with regarding this matter. I find my counter matter. You are not may have it. The child matter requires medical attention. Any neglection, why I am worried is matter. I am equally interested. Matter child should not be made to suffer. I am with your lordship on all the points. What my worry is, my lord, the mother of the petitioner before your lordship is having anger problems, issues, and she is with the consultation with the doctor. Her mother is also having the same problem. Her father is having half blind. They are not capable of taking care. And the only mother, my lord, has the anger issues. And I produced the document before your lordship, which says she will commit suicide if I don't talk. She has got it 10 every time. And
how all those issues are connected with part 3 of the order, that I'm not able to understand.
I want the other side has filed the challenge this stating that
what he is saying is
I am aware of what your lordship is asking is how I am aggrieved with this. I am not aggrieved. Your lordship, my kindly take it, my lord. I am not agreed. My only anxiety is, my lord, I want to know whether the child is given the pills regularly. And the doctor has advised
to the father, why not?
And
also he is supposed to know what's happening.
Yes, my lord, that is my worry, my lord.
Please, my lord, the thing
Another
is,
child has taken them.
please.
Now, what we can do is,
yes,
this part of the order, with regard to this 5 p.m. to 7 p.m., instead of having it for 2 hours like that, at least half an hour he'll have it. Because a boy of that age, he cannot speak for 2 hours on a video call.
Yes, your lordship is right.
And at the same time, the father should see the child also. So what we'll do is, alternative days, let him have that, a half an hour, till the boy is comfortable.
Please,
yes,
boy is comfortable. We can understand, my lord, because the husband is, making allegations upon the mother, my lord, because she is portraying that, she is cutting the calls and he is making all these allegations on the mother, my lord. It is causing huge cruelty and burden on the mother to facilitate video calls for the child, my lord.
Just
The only
leave it.
reason is
No,
that
no,
my lord.
let-
We can provide
because
physical
by
visitation
having
as well, my
No,
lord.
no, no. Let him have, but that need not be 2 hours till the boy is comfortable.
Yes,
That's the
madam.
reason, my lord. Boy is comfortable.
Your
He himself
lordship,
cuts
admit,
the call,
madam.
my lord. He himself is cutting the call when it is made clear to the husband by petitioner, my lord. He is not accepting the thing, my lord.
He's 2 years old.
2 year, 8
2.5
months,
years,
my lord.
madam. 2 years
2
old.
years, 10.
Expect a 3 years boy to speak on a video
Really?
call for 2 hours?
My only anxiety I'm bringing to your lordship.
Can you
Your
make a
lordship.
boy
Yes,
sit
madam.
at one place and do one thing
Yes,
continuously?
yes, my lord. Whichever is suitable manner for the welfare your lordship may fix. I will have no objection whatsoever. My only worry is, my lord, the doctors have said that he has to be operated, surgery. My worry is that to prevent surgery.
Oh,
And
that
this
is your worry.
Only that's my anxiety, my lord.
That is your worry. What is that your question? Please tell the court. What is that you want? Please tell
I
the court.
only want to have a look at the child manner so that I will see that the child is given the pills regularly. Mother is not capable of giving. She is having the anger issues. And when we took her to the counseling, Millard, she expressed that she gets anger. And when she becomes anger, she wants to hit the person whom she likes. And she
These
hit
are
the
matter of
husband
prayer, my lord.
also. And it's a matter of record. And 6 times I have taken her to the counseling for doctor. The doctor says she has got that anger issue. I'm worried, madam, in her anger, if she does something to the child, I do not know how to
From how
safeguard
long
her.
gets it?
I'm thinking myself. I'm leaving
From
it to
how
your
long the boy
lordship.
is staying
How?
with the mother?
From birth of the child, my lord. From birth, he is saying
No. Separation.
separation from 5 months, my lord. When the child was 5 months, after delivery of the child, they have been separated.
Right from 5 months. What is his ailment?
My lord.
What is
Ailment, my lord, I will submit, my lord. A
Well
kidney
and good, my lord.
ailment,
Mentally
by
stable. By birth,
congenial, well,
he has
1 minute, my lord.
problems with kidney-related issues,
Congenial
my lord. Now time.
congenial kidney trouble. One kidney will become enlarged. The doctors have examined regularly and you have to be taken every 3 months. And the doctor says, if every day, every night, the antibiotic pills must be given to the child. And if it is not given, and if the child gets temperature, then you can't help it. Then he has to be operated. That's only my worry, my lord. Your lordship must safeguard that only, my lord. How best your lordship will safeguard, my lord. Whatever the order that your lordship will face, may make, my lord, to safeguard the interest of the health of the child, I am acceptable. I am
So-
acceptable, my lord.
May I just submit this, my lord?
So, where is the discussion with regard to the child's health condition in the order?
Health condition, it is not, they have not challenged any order, my lord. On the last date of hearing before the family court, they themselves, we have suggested any doctor which you suggest, we will take the child to that specialist, my lord. Accordingly, you have taken child to the specialist. He has examined the child in detail and has, given prescription and all those things, my lord. Mother is taking well and care of the child, my lord. Now, doctor has ordered after visitation for 6 months, my lord.
When they have filed an IA before
Please.
the court, where is that IA? IA before the court seeking visitation, or what are the concerns they have raised there?
They only
Let's see
produced, my
that.
lord. It is at
Page number?
71, my lord.
I am looking at WP 14353.
1435, they have not paginated, my lord.
Then in your case, it is there.
Please, my lord. 14503.
Oh. Page number?
71, my lord. One year they have filed is for interim custody, my lord. When the child is aged about 13 months, he has filed GNWC petition.
So they say that interim custody of the minor son.
We have filed objections to that IA, my lord.
Father is a doctor.
No, my lord. He is a PhD holder, my lord.
Oh.
And second IA is at page number 98, my lord.
Yeah, doctor certificate for the mom. Doctor certificate. Counter layer. Counter. Here. The prescription given by the doctor and the doctor certificate, my lord, I enclosed as annexure in my counter, my lord, all the doctor's prescription. R3, page 22 in my counter, my lord.
Why the tablet has to be given to the boy throughout his life?
No, my lord, it can be cured, my lord. Now the child is undergoing treatment, my lord, by specialist, my lord. On the last date of hearing also, we have consulted the doctor, my lord. He has suggested some tablets. After 6 months, we need to examine one more scan, my lord. Basing on the reports
So
of the
for 6
scan,
months, he needs to be given the tablet
no,
continuously.
only 6 months, my lord.
No, no, no. It has to be further again. He has to take to the doctor. Then what happened, my lord? Now it is not increased, but it is stable. So long we take care of the child, my lord, it will be stable, and we endeavor
Hello,
of the
ma
father is, my
madam.
lord, because the,
Your
my lord,
junior is submitting in the court, ma'am.
sorry, ma'am, sorry, ma'am, sorry, ma'am.
Now, in that situation, the child will be getting to feel that this passes an order, according to the child is taken to be if there's any emergency required to occur. And I'm not saying we're not hypothetical basis. There is no facility in Karnataka, apart from the ones in Bangalore, where the child is being currently treated right now, that can address these issues, let alone diagnose. There are no facilities that can adequately diagnose and even medicate, let alone treat or maintain this.
No, no, you're
My
trying
lord,
to.
let me make it clear, my lord. I
you're
am
make-
not
no,
shifting
no,
my
you're saying
residence
that
to
there is
Hubli, my
such an
lord.
emergency situation day to day.
Please, my lord.
Not just emergency, even if there is no emergency, the alternate, if it is regular maintenance.
That's what regular maintenance, he needs to take a tablet. That's number one. And your apprehension is whether she'll give him tablet every day or not is your apprehension.
Yes.
Then the third one is like because you are granted visitation on every weekend on Saturday and Sunday. If the mother goes to Hubli, you will not have the visitation.
Yes.
Because court has given them permission to take them.
Yes.
No, no. That's why I understood. I understood.
My lord, every day medicine has to be administered to the child. They only submitting, my lord. Now, how
Can a
can I
boy
leave the
of 3
child?
years be left here? With
Please,
whom he has to be left? So that is what is not directly possible. You want it indirectly to be done. When the court has not given to you overnight custody, you say that whenever mother goes, let the child remain with the father. How is it? Huh? Now, please show me that he shouldn't travel. So where is the doctor's prescription saying that the boy shouldn't travel? He can have immediate emergencies. Where is that? Give that. Taking a medicine, whether you take it in Bangalore or take it in Hubli, doesn't make any difference, isn't it? What monitoring? Mother is monitoring. Who else is monitoring it at home? Whether she's at Hubli or in Bangalore, mother is monitoring. So please understand, welfare of the child is important for both the parents. But at the same time, you cannot put unreasonable restrictions on the wife. And it has to be always a balancing approach. You understand? Now, court has granted you. You are not questioning any of the visitation that is granted to you. You are happy with Saturday and Sunday, and you're happy with the video calls. And what the senior counsel was submitting is about the travel of the wife. Anywhere in Karnataka, if she travels outside Bangalore, your
Yes.
right to meet
Yes.
the child will be defeated.
Yes. That's sufficient.
No, that anyway, I'm going to modify that order. That's what I'm telling you.
Yes,
Now,
ma'am.
number one, the first condition is with regard to that's what. Please wait. We'll come to that order. Please come. Yes,
Page number 44.
yes. Now what we do is
1456.
Yes.
petitioner father is entitled to the interim custody of the minor child, so and so, so and so. This we will not alter.
Yes.
This will be as it is. Petition is also entitled for interim custody of the minor child. This we will modify, saying that all the festivals that are celebrated in the family.
Yes.
Number two would be that. Then coming to number three, petition has a right of contact with the minor child on alternative days through video call for a period of 1 hour in between 5 p.m. to 7 p.m. Now, what we will do with this is every day, the boy has to take the tablet.
Yes, my lord, he is taking the.
He has to take the tablet. At what time he takes the tablet?
After dinner, my lord.
After dinner.
Yes.
So what we will do is, instead of this video calls for hours together, whenever, like every day, when the mother has to give the tablet to the child, that time she would make a video call and she will give him the tablet. And because that's, what is the big deal? Now you will also, you're also out of all this, this thing that you're not giving medicine, you're not doing that and this. It's not, it can't be a problem. One phone call is not a problem.
My lord,
One
that's
video
not the
call.
problem, my lord.
And
Agreeable, my lord.
it need not be for hours together. It need not be for, it need not be hours together. Just till the boy takes the tablet. It's for the,
If
because
they
father
acknowledge
has,
for that, I am ready, my lord.
Uh.
Because they, again, they make allegations on mother, my lord, because child is able to speak for the entire
not
1 hour
about
and also.
speaking. First
Because,
of all, I'm referring to this video call
please,
for that, let the father know that you're giving the tablet every day to the child. Let him be at that, whatever, he has no apprehensions or about the wife, which this court cannot judge at this point.
It's a matter of
which is
friend.
convenient for both the parties. And you also, you are not losing anything. You're not talking. You're not making the child to talk. You will make a video call. At that time, you will give the tablet to the child.
please, those
Yes,
things
my
will
lord.
be.
Every
Yes, my
day.
lord. Yes, my lord.
And then one more thing, please understand. With regard to the doctor which you are going, what are the medicines that are prescribed? And the father will have the right to know all
But
that.
all the medical documents are with the father, my lord. I am requesting
No,
the
no,
father to give all those
whenever,
documents, my lord.
please
He
understand.
himself has suggested the pediatrician in
Correct.
Bangalore city, my lord.
Whenever the mother is going to the doctor, why not the father accompany to the
My lord,
doctor?
father himself accompanied, my father itself has suggested the doctor, my
But
lord.
let
Only
it continue.
father taking, my lord.
I'll make it a part of the order that
I am ready to, my lord, if there is any need to, for the child to consult the doctor, my lord, I am always ready to take the child to the doctor,
whenever
my
the
lord.
boy is taken for periodical consultation,
Please, my lord.
the father and mother, both of them shall take the boy to the child, to the
Please,
doctor.
my lord, I am always ready to take the child along with the father, my lord. Because what has happened is that, my
one we
lord,
will
the father is
incorporate.
making allegations and he is finding fault with the pediatricians in the town, my lord. That is the reason we have changed 5 pediatricians, my lord, till today.
What we'll do, because father is educated, father do understand the needs of the
Mother
child.
duly acknowledged
What
his
we'll do
academic
is,
excellence.
we'll ask him, let him suggest the doctor. Take it to the doctor.
Lord, that exercise we have done in the family court as well, my lord. My lord, I have taken all those contentions, my lord. Kindly, in my objections, I have taken all those contentions, my lord, because he is finding fault with every pediatrician, my lord. And he keeps on changing the pediatrician, my lord. He's pressurizing him to write all these things, my lord.
No, please understand. If he is finding fault with the pediatrician,
Please, my lord.
that is against whom? Is it that is against you?
No, my lord,
That
is
is
for.
only suggested by
Please,
you.
my lord, now he is making
No, they're
submissions.
not. Please understand. No, it is not kind of an adversarial litigation. We are talking in terms of settlement. We are talking in terms of the welfare of the child.
Please.
No, father is saying that he's making all the efforts, all his, the research to find out who is the best doctor for the child. You also want a best doctor to the child. That
Please.
somebody is doing that exercise. Be happy with it. As far as a doctor is concerned, whoever is the best one, that exercise he will do. You happily take him to that and show it to him, which is in the interest of your child.
Please, my lord, I am doing the exercise, my lord, which is with due respect, my lord.
Don't
What
do
has
that
happened?
exercise. Let him do that exercise.
Please.
You happily take him whenever necessary.
When I take the child to this pediatrician, which is suggested by the father, my lord, he's making allegations against the pediatrician, my lord. He's compelling him to write prescriptions, my lord. He's underweight. He's suffering from all those diseases. He's making
No,
all
no,
these
no.
allegations and making
Please.
prescriptions from that and producing before the court, my lord. Portraying
No,
that
no.
mother is not taking well care of the child, my lord. I'll place it on record, my lord. All those medical records, I'll place it on
For
record, my lord.
client to also understand, making all these things on record and all, and placing it before the court, it will not help him in any way, because ultimately the boy will be with the mother, looking at his age. So let him understand the situation and accordingly act in the interest of the boy, not with regard to their differences.
We are voluntarily providing visitations, my lord, but he's misusing the visitation.
That I understand, Mr. Counsel. You don't have to tell all that. All those technicalities court understands. We are dealing with an issue, you have to understand it and tell the client that you have, now the court will be whatever the good doctor you suggest. That there, the boy will be taken and both the mother and the father will go and have the consultation with the doctor. And every day, this video call, this anyhow you are having on every weekend, this video call for this order will be modified, saying that every day you receive a call with regard to whenever the boy takes the tablet in the evening, so that you are assured that that's the only tablet he takes in the treatment in the night time.
Lord, I'll place all the medical documents on record, my lord. Whether he's taking tablet daily or in twice in a day, or I am not aware of all those things, my lord. I'll place it on record, all these
No,
medical
that is
documents.
nothing on
Because,
record is
my
record.
lord,
How will anybody know by records that every day he's taking tablet or not?
my lord, I'll place it on record, my lord. All the medical documents,
I am
prescriptions of
not giving any
doctor
finding,
prescription.
Mr. Counsel. I'm not giving any finding. I'm only saying this 5 p.m. to 7 p.m. video call, I am modifying it, saying that every day you will call him till the boy takes the medicine. That video call will go on. No, nothing. You don't have to wait for hours together. Yes.
Assurance is given. At the same time, it is clear assurance that the site has been administered. These medicines has been
My lord, let him provide that child is feeling ill, my lord.
When he will take those two medicines?
morning and night, on a daily basis.
Let her take a video and send him. Not to do a video call. Let her take a video and
Oh,
send him.
that is well and
And
good,
for
my lord.
that night time, for that antibiotic or whatever it is, no, that for that a video call.
Please.
For these two, let her send a video to him every day.
Please,
After
please,
that,
it will
after
be
it
good.
is given. Please don't complicate it, Mr. Counsel. Please don't
My
complicate
lord, and
it.
also
Please
on
come.
weekends, my lord. Weekends, it is very difficult for every weekend, my lord.
No,
Because
that's not
mother
what
has to
I'm
spend
doing.
on alternative weekends.
No. Let it be every weekend.
My lord.
When you are not there on a particular weekend, that should be compensated in the week. When you come back, along with the weekend, these 2 days will be compensated within the same week.
It can be made on alternative days, my lord. Because in the midweek we can provide visitation as well, my lord. In the midweek we can provide visitation, physical visitation, my lord.
Yes,
Either on
but
Tuesday or Thursday, my
You're
lord.
not supposed to work.
My lord,
You are at home.
evenings, my lord, 6 to 7. My lord, he himself reported in the petition
So
that
other
custody to
days
be
is
given to
also
the
fine
child,
with
my
you?
lord.
Then instead of weekends, we'll shift it to the
Alternative
weekdays
weekends.
on a regular basis. Not on a regular basis, Mr. Counsel. You have a visitation on a weekend, Saturday and Sunday. Instead of Saturday and Sunday, weekdays, something like Tuesday, Wednesday, if it is fine with him, we'll keep it on that day.
Please, my lord.
You also require some time to disseminate weekend.
Huh?
You also require some visitation that is on weekend. Just on a weekly basis.
They are going beyond, you're not understanding what's going on in the court. There is an order granting you 2 days. You were happy with it. The senior counsel said they don't want anything else. I'm saying instead of weekend, if it is a weekdays, is it okay with you? After giving in weekdays, again weekend, it will not be given. Yes. So it will be on a Tuesday and Wednesday.
Please, Tuesday and Wednesday. Yes.
Yes. Agreed with her. Order passed in I number 2. The father has filed WP 14361 of 2025 and agreed by the order passed in IA number 8. The other is IA number 8.
Please, my lord.
IA number 8. Both the mother and father are before this court. by filing WP number 14503 of 2025 and 14353 of 2025. The father has filed GNWC 349 of 2023 seeking custody of the minor child. The boy is aged about 2 years, 8 months. Two years, 10 months. The parents are living separately from
2023.
2020,
3.
2023 July. It is the case that the boy right from the birth is suffering with a problem, with a kidney problem, for which he has to be under constant medication. It is the case of the senior counsel, no, the court by order impugned in I number 2 had permitted the mother to travel within the jurisdiction of Karnataka in I number 2. When it comes to I number 8, the court had passed the following order in WP number 14503, page number 43 and 44. Extract that order. As passed the order, when a senior counsel appearing on behalf of the father submits that the court, having granted visitation on every weekend, had permitted the mother to travel across Karnataka, and he will be deprived of the father will be deprived of the visitation. Further, it is submitted that the boy is suffering with the health issues, and unless and until the medicine is given continuously, and the boy situation, the boy's health will be deteriorated. It is the submission that the father has no confidence on the mother that she will take care of the interest of the boy, interest and welfare of the boy. It is submitted that the mother has anger issues and she behaves violently, which is not in the welfare of the minor. Next one. When a counsel appearing on behalf of the mother submits that mother is taking all possible steps to see that the medical issues of the boy are addressed. She is taking the boy to the doctor, how it is as suggested by the father. But though he is suggesting several doctors, he himself is having a lot of complaints against them and is compelling them to write that the boy is underweight and several other things, and the same are presented before the court. The mother is voluntarily is ready to has no objection for giving visitation to the father. It is submitted that her parents are staying in Hubli, and where if she stops from traveling to Hubli, as the visitation is there to the father on weekend, and as she is staying alone in Bangalore, it would cause a lot of hardship to the mother. It is submitted that on alternative days, the court had directed for a video call for a period of 1 hour in between 5 p.m. to 7 p.m. And the boy is aged 2 years, 10 months. And it's so difficult for the mother to make him talk for hours together with the father. And whenever the boy switch off the phone, it is shown as if the mother is not interested in boy talking to the father. It is submitted that the court has also passed an order that on all festivals the father is entitled for visitation from morning 10 a.m. to 2 p.m. And it is submitted that there should have been a clarification with regard to what are the festivals. He submits that on these aspects, the order of the family court needs to be modified. Next, having heard the counsels on either side, there is a material on record. The welfare, while considering the visitation, oblique custody of the minor child, the court exercising the parent patronage jurisdiction has to look at the ultimate welfare of the minor. It is the contention of the father that unless the tablets are given every day, it would have an impact on the child's health. According to the mother, she is giving the tablets every day. As the court, as well as the father and the mother are looking at the welfare of the child, and maybe with whatever the relation they have shared, if the father has his own doubts about whether the medicine will be given regularly or not, this court deems it appropriate to pass an order wherein on every day, whenever the antibiotics which are to be given to the father, one video call or the medicines in the morning, evening, the mother can take a video and send it to the father on a daily basis. Next, and then coming to the festivals, the festivals that are celebrated, the order of the court can be modified as far as the festivals in the family, the father is entitled for the festivals that are celebrated in the family, the father is entitled for the interim visitation from 10 a.m. to 2 p.m. as ordered by the court. Then coming to the video calls, the court had granted on alternative days the video call for a period of 1 hour in between 5 p.m. to 7 p.m. with prior intimation to the mother. It is difficult. It cannot be expected that a boy aged 2 years, 10 months can be made to sit at one place and speak to the father on a video call. It is difficult for the mother to compel the boy of that age to speak to the father through video call. Between 5 p.m. to 7 p.m. As ordered by the court, that 1 hour is modified. That as long as the boy is comfortable, he will speak, and there cannot be any compulsion that it has to be for an hour. Next, coming to the visitation on every Saturday and Sunday in Bangalore is concerned, the mother is traveling to Hubli as her parents are residing there. The court cannot compel the mother whenever required not to travel to Hubli. The father's visitation is 2 days a week. By any chance, if she is traveling on that weekend when the father has a visitation, number one, she has to inform the same in advance to the father. Number two, the said visitation has to be compensated immediately in the next week. That is, these 2 days along with the other 2 days in the weekend has to be compensated.
Lord, every weekend it is difficult, my lord. We can provide visitation in the midweek, my lord, because he has to travel because our brother is working, my lord. They have to travel only on the vacation, my lord. That is on weekends, that is Saturday and Sunday, my lord. Alternative weekends, in midweek we can provide visitation, my lord. One Saturday and Sunday. In that coming week, Tuesday and Wednesday we'll provide, my lord. alternative weekends and
Then
the
then there will be
midweek,
a long gap.
well, midweek we can provide, my lord. In whichever weekend there is no visitation, that midweek we will provide visitation, my lord. When there is Saturday and Sunday, and then that coming week, Tuesday and
Where
Wednesday,
do both the people stay?
nearby, my lord, 5 or 6 kilometers, my lord. He can come and,
What are his working time? So what's the difficulty in the weekend? On the weekdays, what is the difficulty for you? No, we have to balance it between you and your wife. So what we can do is 1 week it's weekend, 1 week in the mid of the week.
Please,
That's how
madam.
we will do it. So 1 week it is the weekend, and the next week it would be Tuesday and Thursday.
please. For evenings, my lord, 1 hour. Because child is going to school, my lord.
As ordered by the court between 2 p.m. to 6 p.m. That's what is the order.
My lord, the school is, now child is going to the school, my lord. He has to go to the school
Then-
3 years. Evenings, my lord, from 5 to 6. Or
But
6 to
court
7.
has given you 4 hours. How can you say that it
My
should
lord,
be
that is
1
on
hour?
weekends, my lord. In midweek, at least 2 hours, my lord, 5 to 7, he can pick up the child, my lord.
Why should you not understanding? Why will he compromise with the lesser time?
My lord, now the child is going to the school, my lord.
Then I think I'll not have this.
My lord,
Only thing.
2 to 5.
2 to 6 p.m. on weekends, and whenever it is not, whenever it is not possible, it should be compensated on the other days.
But on the other days, child is going to the school, my lord.
However, then it can be after coming from the school from 5 to 8 o'clock. You can do
Lord,
it.
child is indulged in lot of activities, my lord. He has to feed it, my lord, or lunch,
Thing you
everything should be
can't
done, my
have,
lord.
you know,
My lord, 2
you
to 5
cannot
in
say
weekdays,
that,
it is very difficult.
When a boy, he must be studying in nursery. When he'll come from school, he'll come at 9 o'clock or 8 o'clock in the
No,
evening.
my lord, afternoon, my lord, now the
He'll
child
come
is
by
going.
1 o'clock. It was school won't be till 2 years, 8 months. What are the school timings?
My lord, school time.
What are the school timings?
After coming to the school,
Could your lordship take exhibit R6,
my lord,
my lord?
academic year starts on June, my lord. December, how can we send the child to the school, my lord? Academic year starts on June, my lord.
May I
For a
request?
boy who is in a school, who is 2 years, 10 months, you say about school activities, when he'll come.
My lord, not as on today, my lord, because when the child
We
grows
see,
up, my
it
lord.
will the change circumstances after 1 year we can see. Then, the
May I
one more
have
thing
say,
is-
my lord?
1 minute, 1 minute. One more thing is, the father shall be informed shall be in the group, shall be in the loop with regard to the school activities and parent-teacher meeting, and also with regard to the child's medical needs, father should be part of it. And whenever they're going to the doctor, both the mother and father shall take the boy to the doctor. Accordingly, the writ petition filed by the father, WP number 14361 of 2025 is dismissed as this court finds no illegality with the order, and WP number 14503 and the other is disposed of, whatever that I said in the operative portion.
Only one
as follows.
sufficient, my lord. May I request one sufficient, my lord?
Yes.
My lord, the child is not been sending to the school. School has written a letter. Child has not been attending. They are not sending the child to the school at all.
I have already passed an order that he should be, the father should be informed about all
Yes,
that.
he must send the child to the school. I have paid
Yes,
the
next,
exam fees.
Next call them.
Grateful.
Cell number 10.
For the petitioner, my lords, notice may be issued to the respondent, my lords.
Notice, next.
Cell number 10.
That's what notice.
Cell number 11. 11.
Petitioner in this matter, my lords.
Me.
Yes.
Interim maintenance of 7,000 rupees each has been passed by the family court, my lords.
Page number?
At ink page number. The order is at ink page number 12. In page number 12.
1,000 per month to each petitioner. Who are the petitioners?
My lord, mother and daughter, my lords.
Mother
Wife and daughter. Wife and daughter.
14,000 is granted.
14,000.
What is your salary?
32,000 rupees is what the pension I'm getting, my lords. Now the petitioner is 73 years old. First respondent
What
is,
is the age of these two?
no, she's 20 years old, my lord. She's a major. She has filed an application when she,
Is a major unmarried daughter.
unmarried daughter, filed an application when she was major only, an impleading application in the petition which was filed by the mother, by her mother.
What she studied?
Now she is doing her engineering.
20 years. You said 21 years.
No, daughter is 20 years old.
Oh.
Daughter is 20 years old. She is into first semester of engineering.
Oh.
And wife is 43 years old.
What is she doing?
She is a housewife. She is taking care of the lands, Millards. She basically, Millards, now I am 73.
You pay half of it. Then
No, I am, in fact, I am paying 7,000 rupees for my daughter also because she has to take care of her needs. All that is
you're
being.
paying, it's fine.
No, Millards, now the grievance is this, Millards. Your Lordship may kindly look into the order sheet, Millards. At ink page number. Uh, 70 Millards, 69.
Yes.
Petitioners and respondent present. This is on 1/2/2025, Millards. Respondent paid rupees 70,000 to the petitioner towards interim maintenance. Srimati HBK, advocate for petitioner, filed memo with a certificate issued by the Registrar, National Institute of Engineering, Mysore, towards so and so for the academic of 2024-25. Copy of the said certificate is produced. As per the said certificate, the petitioner number 2 is required to pay college fee of rupees 3,03,087. The respondent is directed to pay the same to the petitioners and further chief of PW1 by 24/2/2020.
Which order is impugned now?
No, now Millards, the impugned order says that an education expenses has to be borne by me.
Where is that?
The impugned order is at 28 Millards.
20?
8. Ink page number 28 Millards. IA 2 and 5 filed by the petitioner number 1 and 2 respectively are hereby allowed in part and order respondent to pay interim maintenance of rupees 7,000 to each petitioners number 1 and 2 from
So
the
you
date
need
of.
to pay how much? 3 lakhs.
Millards,
You need to pay 3 lakhs.
3 lakhs is what now the court has said that I have to pay, Millards. Now Millards, I am one is,
And what is the evidence? How is it discussed? Please come to the order.
yes Millards. Reasons are at ink page number 21.
And he's getting agriculture income of rupees 25 lakhs per annum. Where from it is?
No, that is what they are claiming, Millards. There are no materials to show that also, Millards. In fact, in my house,
Getting rents of rupees 35 to 40 lakhs. Statement of assets and liabilities are not filed.
it was filed, Millards.
What did
Whatever
you
the
say?
maintenance has been, she has also claimed that what is the maintenance that I am getting, the pension amount, that is what she has said, that I am getting the pension
No.
amount.
What is the basis for all this in the statement of assets and liabilities?
There is no basis, Millards. She has simply filed an affidavit saying that I am getting 35 lakhs, 40 lakhs, Millards. I am a retired teacher, Millards.
No evidence.
No evidence. This is an interim application which has been filed.
Please come. Then counsel for the petition submits that the court has directed the father to pay an amount of rupees 7,000 per month to the wife and the daughter. And also directed the father to pay the educational expenses of the daughter. It is submitted that it is brought to the notice of the court that the wife requires a college fee of rupees 3,03,087. And now by virtue of this order, the father has to pay the said amount. It is submitted that the age of the petitioner is 73 years and he is a retired school teacher. School teacher and he has no means to pay all this. The court without any basis and considering the allegations and the case of the wife that is having income of 25,000 from the agriculture and also getting rental incomes as granted this amount, it is submitted that it is difficult for the father to pay these amounts. This court has perused the order and from the order it appears that there are no reasons given to come to such conclusion that he's having 25 lakhs per annum as agriculture income and 35 to 40 lakhs per annum towards the rental expenses. In lieu of the same, they shall be stay of all further proceedings on the condition that the petitioner shall continue to pay an amount of rupees 7,000, shall pay 7,000 by 5th of every succeeding month, and arrears, if any, at 7,000 shall be paid within 8 weeks from the date of receipt of the copy of the order.
No, arrears, there are no arrears, my lords.
That's why I said if any, that same, there's a common order in that if any of these conditions are not complied with, the stay granted by this court stands vacated. Petition is permitted to take out hand summons on the counsel for the respondent. In addition, registry is directed to issue notice. Next.
Still number 12.
Please, my lords.
Devanna Ballari.
Yes.
My lord, this petition is filed by the husband against the respondent, only seeking the directions to the trial court for expedite the matter, as because this petition is filed in the month of March 2024, my lord. As because the respondent father is the retired judge, and as well as the brother of the respondent is the advocate. They are dragging on the proceedings, my lord, and as well as, my lord, the entire proceedings may kindly looked into in the order sheet. There the matter is adjourning for every hearing for 3 months, my lord. And it is very, why is it?
Let me understand, you are seeking early disposal of the MC. You are seeking early disposal of the MC.
Yes, ma'am. Yes, ma'am.
Of which year?
It is of 2024, my lord.
So 24 MC should be disposed of, there shall be a direction by this court. How, why?
That is not the intention, my lord. Because this boy, the petitioner is the working in the software company, my lord. He entered into the company in the morning of 9 a.m. He will come out in the 9 p.m. So that both the father and the mother are suffering with the various diseases, my lord. They could not able to take care of them. And my wife is left out from the house about 2 years back, my lord. Even it is very difficult to me.
No, that kind of orders cannot be.
And only thing is to be involved in this case to dispose the matter at least within 3 months, because I have already given the evidence, my lord. I have already given. My mother is also examined, my lord.
Maybe. The present petition is filed, seeking the following prayer. The MC number 1572 of 2024 is filed on the file of the 4th Additional Family Court, Bangalore, and the direction the petition is seeking that the petition shall be disposed of within 2 months. Looking at the pendency on the file of the 4th Additional Family Court, Bangalore, this court do not find any reason to give a direction to the court to dispose of a 24 matter when other matters which are much older to this are pending on the file of the court. However, the court shall dispose of the matter in accordance with law,
at least
without granting unnecessary adjournment.
At least within 6 months, man. As because the petitioner is suffering, which
There are so many. Every matrimonial problem has its own problems.
that's why I requesting this.
Will not.
What they say, the trial court is saying that bring the honorable High Court order. We will give the short date. That is the thing we are. That's why that's why I submitted mine.
But the honorable court will not give.
And even mother and petitioner also present.
Will not.
I
Those are all
request
not the
you, madam,
consideration.
please,
At least fix a date.
Next, call the next matter.
13. G. Ravishankar Shastri for petitioner.
Petitioner, my lord.
Yes.
Husband is the petitioner, my lord.
Yes.
Initially, my lord, husband files a petition for divorce. In the said petition, my lord, wife seeks for restitution of conjugal rights and permanent alimony. Court passes a decree, my lord, lordships get it at page 16. Petition for divorce was dismissed. Claim for permanent alimony was dismissed. And my lord, court orders that, my lord, there shall be a restitution of conjugal rights. And till then, my lord, the court directs that husband shall pay 15,000 to the wife as a maintenance, my lord. Lordships get at page 17, my
What
lord.
is the nature of this order? This is passed in the MC itself.
Execution, my lord. In the impugned order, it's in the execution.
Where is that order?
Annexure A is the impugned order, my lord.
Annexure?
A, page 12. My lord, may I take for a decree for a moment, my lord?
The decree holder has filed petition for recovery.
Yes. My lord, the wife then, my lord, files a petition for execution, my lord, without joining the matrimonial house, my lord, in spite of I issuing a notice to her and come and join the matrimonial
Please
life.
come again to that order.
decree, my lord, tricky, very tricky order, my lord. Page 3, I may read, my lord.
Filed with the petitioner under section is the same is, who is the petitioner?
Husband, petitioner.
Husband files for restitution.
Divorce,
Divorce is dismissed.
dismissed. Wife
Consequently,
seeks
the counterclaim of the respondent for permanent alimony is also rejected.
rejected. Then, my lord,
Hereby directed to restore conjugal, so her restitution of conjugal rights is allowed.
allowed.
And to discharge his matrimonial obligations, taking the respondent back to her matrimonial house within 3 months from the date of the order.
That
till
till
then,
then,
the petition is hereby directed to continue to pay maintenance to the respondent
At
at the rate of 15,000 per month as per.
Order.
So this judgment and decree is dated
that is, my lord,
21st February 2022.
please, my lord.
So then where is your notice?
My lord, my notice, lordship may kindly see, my lord, annexure G at page 29.
Page 20?
29, my lord.
29.
That is on 10/8/2022.
10/8?
2022. For which, my lord, she replies, there are other some monetary dispute between the
For the
parties.
submit that he has made several attempts to comply with the judgment, but all the attempts made by the family members turned to be futile and thereby you're not. So even otherwise, so from February to August, you didn't do anything?
My lord, we have paid, my lord, up to the date of decree we have paid. There is no dispute.
No. From February to August till you issued the notice.
Yes.
What did you do?
My lord, till that, my lord, there was no payment. In the execution proceedings, we have paid, my lord, to extent of
So
1,50,000.
at least for the month of March, April, May, June, July, August.
That is covered.
6 months you need to pay.
Yes. That was
6
paid,
months,
my lord.
15 into 6.
90,000.
Huh?
90,000, my lord. And in execution, I have paid 1,50,000 now, my lord.
You already paid now.
On 26/7/24, 5,000,
Client and his
27/8/24,
family members
1
turned
lakh.
futile. Where do you get that? Where she says that?
My lord, in the memo of calculation, my lord, at page 26.
No.
Please.
Her response. Her response to your notice.
And next annexure, my lord, annexure H.
It
Age
was replied
31.
on when? 22/9/23.
29/8/22, my lord, she replies. And at page 32, my lord, she again, my lord, says, there are other financial dispute between the parties and I should pay that amount, then I should take a care. Page 32, may I take, my lord, directly? She. This is where, my lord, she raises another dispute stating that 1 lakh rupees I should pay to her brother and then, my lord, the other proceeding shall take place. A new plea rises. Then she files a domestic violence case, my lord. There also she seeks for maintenance. And she does not, my lord, wish to join the matrimonial life. Though there is a restitution decree, my lord, she does not file for execution. On the other hand, my lord, her interest is only to seek maintenance, my lord, in all proceedings.
When counsel appearing to the petitioner submits that after the order of the judgment and decree passed by the court in MC number 65 of 2019 dated 21st February 2022, petitioner has made all his efforts asking the wife to join the matrimonial home and he has also issued a notice and the wife has failed to join the husband. In fact, in the she went to she filed the EP in the EP proceedings. Till now, he has paid an amount of rupees.
Total amount so far paid is, my lord, 6 lakhs I have paid, my lord, so far.
He has paid an amount of rupees 6 lakhs.
Total amount.
6 lakhs. This court has perused the notice and the reply notice and also the judgment and decree passed by the court. Considering the submission, there shall be stay of all further proceedings. Notice to the respondents, see the hand summons. Once the memo is filed, is the matter. Yes, next 14.
Please.
Rupesh Kumar S for petitioner.
Petitioner, ma'am.
Yes.
This case I have challenged the order passed by the trial court, wherein
The trial court has allowed the application filed by the first respondent wife, my lord, to implead a third person with whom the second respondent has had an affair, my lord.
Is it the MC is filed on for adultery?
Adultery and cruelty, both, my lord.
Then what is wrong in it?
My lord, the wrong is that the trial court, my lord, paragraph, page
No,
number
without
20.
making that person as a party,
Yes,
that,
yes, I
she
agree, my
cannot
lord.
maintain
I
that
agree, my lord.
petition.
The trial court, my lord, at page 24, my lord.
Mm. Yes.
In the second line, my lord, the petitioner has also stated that she is having documentary evidence with her to prove that the respondent is leading adulterous life with the proposed respondent, and she got produced the photographs, video and audio recordings before the court to substantiate her contention. So, my lord, the photos that are submitted by the first respondent are different, my lord. I am not the one in those photographs, my lord.
Who are you now? You are the proposed party.
Yes, my lord. Yes. The photographs produced by the first respondent, my lord, who is the applicant before the trial court, has not produced
Where are
my
those photographs?
I have not produced it, my lord, but I have got it here through the
Take that.
application. So I am not the one, my lord, in those photographs.
Who are you? Where are you? Where is your photo?
My lord, I have it in my mobile, my lord. Not permits.
You have to place that also if you are.
Yes,
That's the
yes, I
only
agree, my lord.
contention.
I was sent in the morning.
This is smarter day after tomorrow.
My lord, I pray for stay of further.
Tomorrow, because I have to convince myself what it is.
I can show the photo, my lord, right now.
You file it. You file it on Friday. Friday. Let's just start on Friday. Tomorrow. Next.
Cell number 15. Cell number 15.
In this case also, Mela, on Sunday, for father visitation rights were granted by consent. Memo.
Notice
Thereafter,
to the-
she shifted to Hubli. I
Notice
want
to
at least on the festival days, I have the child, Mela. The child is about 9 years.
Write notice to the respondents.
Yes, Mela, I'll take notice.
And summons. Once the memo is filed, list the matter.
Yes, sir. I will.
Cell number 16.
Reply for the petitioner, madam. The husband's petition, madam.
Yes.
Wife sought for madam the maintenance under section 125 of CRPC, madam. Along
How
with
much is granted?
madam, the 15,000 to the child, madam. For her, madam, no maintenance is granted. Madam, the trial court, madam, even though observed he has no madam avocation, and even then, madam, the 15,000, madam, from the date of madam
The respondent husband is directed to pay monthly maintenance of 15,000. Please come to the order. What is the discussion with regard to your financial
Annexure
capacity?
A, madam. Annexure A is the impugned order. And madam, relevant para, madam, I will take madam page number 23, madam, on top.
Her monthly income is 30,000. And
Madam,
what about his
her
income?
income, madam, for her, madam, no maintenance is granted, madam.
No,
Even for madam, the petitioner is concerned, madam, he hasn't madam any income. And madam, that could be seen from page number, madam.
Have you filed your statement of assets and liabilities?
Yeah, he has filed, madam. She has also filed, madam. So he has no income, madam, at present. He has no avocation. And madam, the 15,000 order to pay from madam, the 2111.
What is your income? Then tell the court.
Madam, earlier, madam, she was working in madam, the one madam, real estate company, madam. He had some money at that time, madam. In that time also, madam, he has transferred through bank to her 25 lakhs, madam. She has purchased the house, madam, where she is staying. Madam, now, madam, he has removed from the job because madam, due to matrimonial dispute, he could not concentrate on that. Madam, he has removed from the job. Now jobless, madam, he is searching for the job. Now, madam's wife is claiming, madam, this 15,000 from the date of madam 21/11/2022 till madam the son attaining the majority. That is 2000 April 2024 he attained majority, madam. Between that period, madam, she sought madam the interim maintenance. Madam, since madam
When he attained majority?
Madam, April 2024, madam.
April?
2024.
April 2024. Then pay some amount. We can't grant you a blanket order.
She is also aware that madam, she has no income.
Pay
Madam,
5,000.
that is observed in madam.
5,000. The land counsel the petition submits at the court without considering the financial capacity of the husband has granted 15,000 as maintenance. The wife is earning and he is not in a position to pay the maintenance. Considering the submission, same stay on all further proceeding on the conditions that he shall pay 5,000. He shall pay the arrears at 5,000 from 21/11/2020 to April 2024. within a period of 12 weeks.
Serial number for
Notice to
admission.
the respondents.
17, Shivramu HC for petitioner, Rendranath Dole.
Yes.
It appears the file is misplaced.
Request of so and so. What is this?
My file is misplaced, Your Lordship. Can it be taken up Monday, my lord? I will check up, my lord. What is this?
Why your files are being misplaced like
Then
that?
I don't know, my lord. It was not traced, my lord. That's the reason, Your Lordship. Monday, my lord.
You have any urgency in this? It can be next week. List the matter on 7th of July.
Grateful.
Serial number 18, 19 adjourned. Serial number 20. Please call the order.
She was asking for adjournment in the morning.
Requesting for adjournment, my lord.
Because you're not there, I said, because it appears the memo is moved.
Yes, my lord, it's only for
What
enhancement
is it?
of maintenance, 8,000 rupees has been granted.
Uh,
I asked for enhancement.
Enhancement.
Your
When do you
lordship-
want?
Your lordship, in this case, they are.
When do you want?
2 weeks, my lord. Because I need
Date may
some.
be fixed.
This is matter on 16th at the request of land council, the respondent. Yes, 21,
Serial number 21.
give a date on list this matter on 17th of July.
Serial number 22. Vijeta Nayak.
Appear for the respondent counsel. We have filed NOC Wakalat today. Kindly have it next week, any day.
List the matter on 14th, on 8th of July at the request of land council, respondents is 23.
Serial number 23. Revanna Bellari. Rajat, the respondent,
This also, list the matter on 22nd of July,
22nd July.
is 25.
Yes. Serial number 24 adjourned. Serial number 25.
Your lordship, appearing behalf of the respondent, your lordship.
Yes.
Syed Khalil Pasha.
Petitioner, ma'am.
Your lordship, one submission, your lordship.
List the matter on Tuesday. Yes, next, at the request of land council for the husband.
Serial number
Yes.
26. 26 Prabhu L for petitioner.
Petitioner, my lord.
Where is the respondent?
Don't know, my lordship, in the last occasion.
Let's see, give the order sheet. This matter is posted for appearance of party that stated there is a likelihood of settlement. While submitter, she is ready to compromise the matter provided an amount of 3 crores is paid. So is ready to transfer the property which is worth ₹3 crores and then counsel the vice submitter is not interested and she does not want to get into any litigation or other issues. If the amount is paid, then there is no. Yes, well, what have you decided?
My lordship, we are ready for transfer the
Not
property.
transfer. Again, don't repeat the same thing. They said that they want money. Are
But,
you ready for it or not?
But yesterday also I informed them, but till they did not
Let's
inform anything.
Let's this matter, it is submitted that there is.
My
no
humble,
scope for,
one submission is, my
This
lordship,
matter
the
on,
matter is listed,
August 5th.
my lordship, one humble
if I
request
may.
is, the matter is listed before, honorable trial court yesterday. And their fixed date for Monday for assets and liabilities and other,
The file.
lordship, my humble
Lordship, if
submission
I
is,
may, our
my colleague is
petition.
online, my lordship, he is submit.
Listen, yes, next,
Serial
26.
number 27.
Lordship, if I may.
Yes, 27.
27 Manjunath PR.
I represent the petition.
Abdul Ansar.
This is the father's petition.
Seema.
That the place of visitation of children has been changed from Spandana Center, Hassan to Arehalli Police Station.
For
That is
yesterday's matter. So what I was telling the counsel who represented you yesterday,
Please.
that why should the children travel 15 kilometers? That is one aspect.
Please.
Other thing is, I asked the counsel for the respondent to tell the place which is convenient for them also, a public place. For that he sought time.
May I make one suggestion? Let the children be given to the custody of the father on Saturday in the afternoon. We will drop them back on Sunday evening.
No, you are asking
But that
something
would-
beyond
No,
what
no,
is
no,
granted.
no. But he is only father, my lord. He is the father of the
Don't
children.
know, we don't know
His
what is the
father-
relation
but the
between
respondents
them.
are the grandparents. My mother is no more. She committed
Is the
suicide.
counsel-
She committed suicide.
Land counsel for the respondent is not present. Counsel the petition is tomorrow or Monday.
Pass over, my lord, at least
Pass or not possible. Tomorrow or Monday?
tomorrow. my lord.
Tomorrow.
But
Inform him.
The other relief which I have sought is expediting the proceedings.
Which year is that?
2023, my lord. Now it is on, and in
Which
the
court
fag
is
and
that? Which court is that?
family court Hassan, my lord. There are only few cases there. my lord.
We'll pass such an order, let him come.
But if custody is given on Saturday, my lord, we will
We'll
drop
find out
them
from
back
the,
on.
we'll find out from the mother, please inform the
No,
council.
mother is not there. Mother, she has
Mother is in the sense, whoever is the,
grandparents.
yes, grandparents.
Cell number
Tomorrow.
28, Geeta Devi MP for petitioner, SK Pratima.
Yes.
Plus the one, this thing, let there be twice in a month, which I had submitted yesterday, that regarding the visitation, as regards the maintenance, your lordship.
Regarding the maintenance orders, we will confirm the order of the court. Let the court decide that application, what is pending.
Modification.
What if she, and you also, if there is sufficient material to show, whatever enhancement you are seeking, both of you are at liberty to do it before the court.
Because I've already pointed out that the bank statement states this much. So
No,
because
she files another.
that is recently.
Recent one, that's what I'm
Yes,
saying.
after filing
So,
of this.
yes,
writ
no, the court
petition.
will consider that also. Till such time, if you're entitled for any enhancement, no, our application is being considered for reduction, your application for enhancement also shall be considered in the same thing. You also make an application.
Yes, my lord.
Both
Then-
will be considered,
Then I
basing on the
will
material.
make an application. Because at that point of time, my lord, this was, when this was passed, his salary was 3,35,000.
That's what.
Based on that, my prayer would be, he has to bear the educational expenses proportionate to that.
No, what do you say? He lost the job in the month, or like you say, recently or whatever. So from the date of application till the date that order is passed, he was having 3 lakhs. Why not, mother's salary is 1 lakh, his salary is 3 lakhs. Why that proportional, this thing will not apply at that point of time? When he was having income.
Lord, the question is, what is the expenses for the child has
That's
not been
what-
quantified, has
actually-
not been quantified. Then if
That's
it,
what we will do
if
is-
the court quantifies that this is the requirement for the child, then
So
proportionately.
that, now the order would be, now I'll direct the family court, apart from deciding your application from prospectively with regard to he lost his job and all.
Plus-
And you can also adduce your evidence.
Because till that is passed.
That's why I'm further,
I'm
saying-
sorry.
I'm saying that. So before that, his salary was 3 lakhs. First, let the court decide all through what were the expenses of the children, of the child, and what would be the proportional share of the parents considering their income to the child. Let it decide that aspect also.
Because that would be, may I make a submission? If your lordship were to pass that now, obviously he will say 75,000 is my salary because I have quit the job, and he'll produce that agreement.
No.
And then she will be
I'm
asked
saying
to-
when it was 3 lakhs.
3 lakhs, yes, my lord.
With regard to whether it is 75 lakhs or not, that is for both of you to adduce evidence.
Look, that's what,
They are saying 75,000.
correct.
You
That
say
is
that, no,
now.
that's not something else, it is your case. That
No,
you
no,
can-
Mills, it is, he has quit the job and he has joined, and now he's showing 75,000. Obviously, the court will look into only that. So proportionate means then the court will say mother has to pay more. That is what I'm saying. It had to be proportionate that time. Now that proportionate, if your lordship were to pass, then she will be asked to pay more, isn't it, my lords? That would not be appropriate is what I'm saying.
Lord, what I'm saying, Lord, child's education expenses, I'm willing to bear 50%. Because I said
That's where they are coming. 50% is what they're saying, that they're not 50%. When for mother's salary is 1 and father's is 3, it should have been proportionate to the salary.
My lord,
In fact,
my
I'm
lord, the
sorry.
question was this, my lord.
I'm sorry to
Child-
interrupt, but I wanted a settlement only for this, that is why. Not for the, even if they did not agree for the main matter because they are seeking joint and parenting and all of that. At least when it comes to this, till the disposal of the case, can it be regarding the, like I suggested for visitation overnight, can that be even educational expenses?
Lord,
He can.
my lord, that is
All
where
right.
we are. Educational expenses, my lord, the child was studying in a good school. Now she is removed to a school which is elitist and 3 times higher school fees. Now what I was paying for the child for the whole year, now I'm paying the same so much or closer to that or double more than that for the half year fee.
as my 50%. So it is also burdening me, my lord. That's one. She has chosen to move to that school, then she also has to pay that, my lord. As 50%, let there be a 50%.
What is the present
No, no.
school fees
It
of
is,
the boy?
Milord, it is not thrice the amount or anything like
What is the
that.
fees now?
No, that this Frank Anthony Public School is all the convent schools were 60,000
Per
Now-
annum.
Per annum. Now it's 2 lakhs.
Plus that.
Now this is at every year there's an increment of 5%, 8%, 10%. Beginning of the year they tell
Frank
us.
Anthony's was 1 lakh, I'm told.
And the school is a good school, 2 lakhs per annum fees for both the parents. I don't think you should make any.
Because it was
Therefore,
not
my lord,
60,000.
therefore, keeping the child's interest, I'm saying 50%. It's more than that, my lord. 60,000 where it was and now it's 1 lakh rupees I'm paying. It's not just 1 lakh rupees. Apart from that, abacus and various other classes, chess, etc.
So it's 1 lakh and 20,000 per month you are paying now.
20,000 plus
It's
all
not
these,
60.
all this, my lord. All this, that is the 2,20,000. And she, whenever she sends the bill, I have produced it along with
Plus
my.
it's not 60,000. It can be clarified.
It's
It
here.
comes close to, yes,
No.
FAPS, yes.
FAPS, no.
Including transportation and everything, it would come to 1 lakh.
No,
I
no.
have ascertained from her,
Transportation
in
is-
fact,
Transportation is like just to going to GPO, their house and the school.
no, I'm talking about from her house. If transportation were to be there, you would have spent that.
Whatever. Now if you're
It would be 1
speculating
lakh
on this.
there. Now it is coming to 2 lakh. I
Lord,
think
apart from this, my lord, if my petition has been taken, my lord, the memo of calculation is filed for cricket, chess. All this, according to the father, it should have gone into the 20,000 rupees. My lord, the child was only 6, 7 years old. As he grows older, there may be additional expenses, whatever, my lord, then it's a different matter. Now, when the child is a small child and
But at one breath you say that you're ready to pay 50% and you file an application for, reducing the amount.
because, my lord, now at this is my problem, my lord. Now I'm paying 4 lakh rupees a year. As on today, I'm paying 4 lakh rupees a year for the child. That comes to that amount, my lord. And so some respite for me is what I'm asking, my lord. I may lose my job completely. I'm not in a regular job. If I get a regular job, then again, a change circumstances, I will be paying more.
So now,
Look,
is it
even
that, no, if this order is confirmed, without any further direction, is your client ready to withdraw that petition? Or
Withdraw
you still
the-
pursue with that?
Withdraw the
That the petition to modify the order?
application for modification. I will ask him, my lord.
plus, can I point out to the bank statements, the interest amount itself, mutual funds and everything runs into more than 20 lakhs every month he earns. It's here, what they have produced itself.
Tell her, point out to her that. What is that you can point out? That,
Yes.
once you.
I'm trying to convince him, my lord.
So she says,
Because in fact,
every month
the
you're
bank
getting
statement-
interest of lakhs of rupees
No,
towards
my lord.
mutual funds.
Mutual fund, it's here.
He's referring
The
to very-
statement that you
Let
have
us see,
produced.
Let us,
At page,
In which?
page 2.
In the next writ petition
It
or
was
the
a
first writ
memo.
petition?
Memo dated.
In your writ petition? In her writ petition?
Belongs in their writ petition,
Ah,
yes.
yes.
Memo dated 24
which
to.
page? Which page?
Second page.
Second page.
No, it's in first writ petition, not in the second writ petition. The memos are not here in this.
You're looking at page, which month you're looking at?
No, I'll just point out because bank statement starts with that.
Page number?
Plus it starts from 2.
Page 2.
Page 2.
Hmm.
I will just, the withdrawals, I will come to that and I'll take your lordship to the deposits and the mutual funds, lots. Here at withdrawals itself, Bajaj Finance Limited, Milords at, I don't know the line. I can tell you the, I can tell
Date.
the
Amount.
Take the
amount.
date.
4 Milords, 13/4/2023, 20 lakhs. Next 13/4 itself, Nippon India, which is again a mutual fund, 5 lakh. Then 15/4 ICICI Pru floating interest, 10 lakh. Not 17/4 Franklin India floating interest, that's again a mutual fund, 5 lakh. Then 17/4 HDFC low duration fund, 10 lakh. I'm just pointing out the major this things, lots. And page 5, Milord. Page 5, 6/10/2023.
6,
6/10/2023.
10, 2023.
Fee for legal, whatever, 2 lakhs. I don't want to point out any names here. I'm just pointing out these laws. Next page, 1/12/2023. For healthcare deposit, 9,39,600. Lots, it's at page 6. Next page. 1/12/2023. And then, Milots, I'll come to page 8. Page 8, 33/2024, at the last, there is 59,563 and 1,38,689. This is the Bajaj Finance, both. And then, Milots, coming to page 11. Page 11 at serial 41, I would say, Milots. That's again the legal fee, 1 lakh, then 46, 1 lakh. Then at page plus 14, it's 5 lakh floating interest, page 124, page 14. 125 is 3 lakh. All these are interest, Milots. And the next page, 15, 120, 128, 3 lakh.
All this can be explained, my lord.
And then, no,
I will explain all
it's
this.
explainable, but I am just pointing out to the court, that's it. And then there is Bank of America, where he would receive in dollars, that they have produced.
Refer to the pages.
Milots, that they have produced only 2, 3, that is page 31, Milots.
31.
31.
It's 31.
The amount received in dollars is what he has stated. I will not go into that. And then they have produced the IT returns. And then the healthcare, Let's Doc healthcare, this thing, which he says is currently employed. So these are the documents that he's produced. In ICICI Bank statement itself, the floating interest and the fixed interest would run into more than 20 lakhs.
Lord, what he says just now, as she was mentioning, Lord, in the first page, page number 3, your lordship can see that, my lord, in 1/4/2023, when he quit this Brillo, when the Brillo, the job got over, he got paid 70 lakh rupees. That is what he has invested here. Lord, his only assets that he has is in mutual funds. He does not have a site. He does not have any other investment. She also has mutual funds. Now, let her also be transparent on this. All this aspect can be considered. Well, now, this question is, this 70 lakhs, instead of keeping it there and getting an FD of fixed deposit and having fixed interest, he is now investing it and he is reinvesting it. That's all he is doing, Melo. That's what he is doing in the mutual fund, whatever he has, the savings that he has, that is what is taking care of him in this situations. It's not that he did. She also has mutual fund. Let her also produce what is her current salary and what is her mutual fund.
The reason for the court to direct the petitioner to produce this was simply because he himself had accepted, the earlier court had told, 1,16,000 is her salary, he himself has accepted, and 3,35,000 as per the affidavit of assets and liabilities is what he himself has stated. So that was the reason the court said.
No, the reason the court said, my lord, was I had said that his salary has come down, the change circumstances, and I produced a salary slip. Salary slips are here. Even now, the salary slip is so much. So when the court said, now produce a bank statement, are you receiving this one?
No, on those mutual funds, what are the interests he is receiving every month?
Mutual fund is an investment, it's growing, my lord. It's not an interest that he would receive. Only withdrawal. Your lordship, you're seeing this withdrawal here. Certain sum of money which he is now withdrawing for his expenses when he did not have a job from February, from certain months, April to September, he had no salary. He withdrew for his own expenses, for running expenses. For these 6 months, 8 months, he won't have any salary. But he could perhaps buy a site or buy an apartment. Then the money gets locked. How do I make a living for myself other than this 1 crore or 1.5 crore, whatever amount that I have? Only on that I have to make my living for my lifetime. I may not get a regular job with all this recession that's happening in the IT industry.
Oh, instead of fighting all these litigations.
Yes, exactly. Just for 1.25.
One after the other, let them No, you also, no, what they say is, for all other activities also, he's paying a lot of money to the child. So like, you please make it specific that what the father has to do.
Sure.
What
I'll come
are
up
the
with that.
expenses of the child?
I'll come
Every
up to
month,
the
not
court.
like how he is saying that he's paying for that, this and so many.
All right, I'll come up
When
with
you're
that.
asking that you should pay for it a specified amount, it should end there.
I understand. That's exactly why, my lords, just for 1.25, I think they could arrive at a settlement till disposal of the petition so that they, instead of keep on filing reduction, enhancement or visitation, this or that, both visitation and payment. I think the father and mother, if they're okay with regards to this, not for anything else, they could have file a joint memo, agree on certain things. That is why I fairly submitted that twice in a month, let the child be sent. I thought they will also come forward because it's hardly 1.25. That is all per year.
No, he's paying already 1.25.
Plus,
are paying
no. What she's asking, enhancement because of 3.35
No,
lakhs.
no, he's paying 1 lakh. That is 1 lakh school fees.
Yes.
And 20,000 per month.
Correct.
That comes to 2,40,000.
Well, it's 1 lakh per
3
year.
lakh 40,000, my lord.
3,40,000
And
total.
apart from that, I am paying all this. She files this memos, which I.
No, those are
Council-
not.
The council
No,
has-
that's why, no, that's what I'm saying. Let's have a clarity on that. Like what exactly is the husband's contribution to the child?
May I produce the list Monday or whenever the court can list it? I will file a list, the expenses that the father is required to bear and the mother is bearing, whatever it is. Based on that, let the
But
court
he's
decide.
giving already 20,000.
No, based on that, let the court decide whatever. I'm fine with that.
It is, he says it should be included in this 20,000 rupees.
No, that's what I said.
Take care of that.
I will find out what else he is bearing apart from that and I will produce it before the court.
Place it on record, my lord, page number 76.
Because you already, they produced something.
It's
Yes,
there.
I will just
In line
verify
with that,
whether.
you can find out from her
I'll
also.
find out. I'll find out and I'll also produce a list.
Monday, list the same, in this under the same caption.
Till number 30. 30. Ali Shantappa Basappa for petitioner. Lachinmat for respondent.
We'll have it some other day. We'll have it some other day. You appear in 30?
21, my lord.
Oh, Lisa's matter on say 28th of August. Yes.
21, my lord. The matter is settled, my lord.
Settled.
Withdrawing the
Of
request.
August.
21. You that.
21.
Settled before the family court.
Other day, I have withdrawn 2 matters notes which I have filed. This was connected.
A memo is filed stating that the matter is settled before the family court. And that is MC number 3 of 2024. And no further, and the memo is filed seeking to withdraw the petition. It is submitted that all already 2 connected matters are withdrawn. Accordingly, dismissed as withdrawn.
Please, pardon me, ma'am. With permission. The matter serial 20 has been adjourned because I am engaged in the quota number 15.
Which one is adjourned?
23, ma'am.
Nothing is adjourned.
I appear for the respondent in 23. Want to bring to my lord's judicial notice a point. Last July, my lords passed a direction to complete the trial in 6 months. It's a 2019 litigation. Pursuant to which, my lords, we approached the Supreme Court in another case, my lords. There also, my lords, the Supreme Court directed the trial to be completed in 2 months from April 24th onwards. Quite naturally, my lords, June 24th is the day within which the trial must have been completed. If my lordships kindly recollect, on the last date of hearing before this honorable court, I moved a memo for the end of the list and obtained a stay wherein they had misled the honorable court seeking my lords, recovery of the amount. My lords, the Supreme Court clarified it is from the date of the order and not pre the date of the order. That order, my lords, directed completion of trial in 2 months. That was later clarified by another order passed by the Supreme Court wherein 2 months. There, my lord, the petitioners in this case, I am for the respondent, petitioner wife in this case, is, my lords, prolonging the proceedings in the trial court on the ground that there is a petition preferred before the High Court. It is pending consideration. Wherein this petition is preferred.
23?
Please, my lords.
This is 23.
Wherein this petition is preferred, challenging, my lords, the rejection of an IA where they had sought for re-examination of a particular witness. My lords, in the same case, have previously also dismissed it, where they had sought for recall of another witness on the ground that this is just to protract the proceedings. That order, my lords, I will
I have
provide.
granted stay in this.
No, there is no stay operating.
Then
And this honorable court has also
It
made
is to-
clarification. This
it
will
is
not
for-
come in the way
It
of
is
the
for
trial.
hearing and for admission, my lord.
Huh?
It is for hearing and admission, my lord. This man, in this matter, my lord,
tomorrow I'll hear and pass orders.
My
This
lord.
is matter tomorrow.
At what times?
Tomorrow.
Tom-
We'll hear and pass orders finally.
I'm
Because
having,
we can't.
no, I'm today itself, I'm ready for a.
Then give it.
My only place on record is the Supreme Court order. That's all.
But yes, please
My lord,
argue.
I am permitted to submit, my lord.
Yes.
Kindly submit, my. But I kindly see the.
Let us look at the impugned order. Straight away come to the order. We'll
Please,
read it.
please,
You
ma'am.
can submit.
Please, ma'am. In the impugned order, my lord,
Yes.
in the page number 7,
Page number?
page number 7, pagination 57, pagination 57, order page number 7,
Please read. From the reasoning part, you please read.
please.
From the reasoning part, please read. Point number 1.
Pair number 11,
9.
pair number 11. I may take the pair number 11, madam.
Please.
Kindly here. Admittedly, this petition is filed by the petitioner against the respondent seeking degree of divorce on the ground of reality. Petitioner has made allegations against the respondent in the petition. The burden is on the petitioner to prove the allegations made against the respondent. Burden is not casted on the respondent to prove the allegations made against her in petition. Since the respondent has
Please
extensively.
come to, I have seen it. Please come to the affidavit in support of the IA.
Yes, madam. And it is at page number 38.
30?
38. Please.
Yes.
Page number 38. In pair number 2. On 24/10/2024, this honorable court is pleased to be taken as cross-examination for respondent side to a suitable as nil and posted to respondent evidence. On 24/10/2024, I made request to give coordinator with application and same was not issued. And at that time, my advocate Pudupuli has not been appeared from Rani Bennuru as he had more cases there. And for that reason, this honorable court is taken as only on my side cross-examination is taken as nil. And coming into the para 3, on perusal of the records, I am advised to file an application seeking permission to file objection to DNA report. As
DNA
same was-
report was filed on 19/8/2022.
Pardon?
DNA report is
Yes.
dated 19/8/2022. For that, you want to file objections now?
Not in the, and laterly I appeared in the, laterly the council has changed, my lord.
Council doesn't matter. Whoever is the council, council
please.
is there.
My-
So for a DNA report of 19/8/2022, you will file the objections now.
That report has been filed in the, filed on, in the 2022, my lord.
Even before that, my lords, I don't want to make any allegation. My learned senior was present at the time of the DNA being recorded. He is a witness. In fact, during the evidence, the doctor concerned says, if the question was posed, who was present at the time of collecting evidence? They point out that the counsel and the petitioner there said both were present at the time.
The thing is involved in this case, my lord, only seeking permission to cross-examination PW1 by recallings, which were not.
But DNA report is given by PW1.
DNA report is on record and he was cross-examined, my lord.
Is it given by PW1?
Pardon?
DNA report is given by PW1.
No, my lord, no, my lord.
Then how can you cross-examine PW?
Because my lord, the PW1,
report?
because my lord, PW1 has induced the director CFSL Hyderabad in order to get the report in his favor. And further, and more that your Honor kindly see has alleged in the petition that the respondent is with the relationship with the one Mr. Jagdisha and other several allegations have not been cross-examined, my lord. That's why I request to this honorable court for kind enablement to cross-examination, which were not cross-examined properly and effectively. And by cross-examination, your Honor, what is happening to the other side, my lord? That's why my request to this honorable court, my kindly look into, and even the perusal of the order portion of the pair number 11, what has been held by the trial court is this, my lord.
From the Supreme Court judgment.
Pardon?
Basically relies on my lord's two judgments Wherein previously, my lord had directed for them to complete the trial in 6 months.
ಅಲ್ಲ ಅವರೇ ಮಾಡ್ತಾ ಇಲ್ಲ ಇವರ my lord they have not been conducting the case in speedy manner
And where is
but
the
they are
Sup-
taking
where
the
is the
time my
Supreme
lord
Court one?
even they bringing the order to dispose the matter within 2 months but they are not cooperating to the trial court they are alleging against me the wife
And this, my lord, is passed in the month of, sorry, June 25, wherein the order dated 23 was reacted. And finally,
The agreed with orders passed in I number 15 dated 18 December 2024 in MC number 306 of 2019, the wife is before this court. The wife had filed an application before the court
at a number 15
before the court
at an exercise
seeking
at an exercise
to recall PW1 for further cross-examination. And the same came to be allowed by order impune. While dismissing the application, the court has observed that the petition is filed seeking divorce on the ground of cruelty. The petitioner has made allegations against the respondents in the petition. The burden is on the petitioner to prove that allegations made against the respondent. Burden is not casted on respondent to prove the allegations made against her in the petition. The respondent has extensively cross-examined PW1. The respondent has not made out sufficient grounds to recall PW1. The respondent has not specifically stated which are the points or facts let out by previous counsel in the cross-examination of PW1. Merely the respondent has changed the counsel will not be the ground for recalling PW1 for cross-examination. And the court has also, as referred to the criminal petition number 4877 of 2024, that a mere change of counsel cannot be a ground to recall the witnesses. Hence, the court felt that there are no sufficient reason grounds to recall PW1.
in para number 18 of the affidavit I have stated man specifically
To recall PW1 and accordingly dismiss the petition. Then counsel appearing for the petitioner submits that the court without any basis has dismissed the petition. It is stated that a DNA report is filed, is dated
23/3/2022
Where is affidavit? The DNA report is dated 19/8/2028. Earlier advocate has not filed the objections to the DNA report on 19/8/2022 due to his rush of work. Though the party has given instruction, and as for medical science, the client is the party is having a good case. It is submitted that the court, without understanding without properly appreciating the reasons for what this application is filed, has simply dismissed the petition. It is submitted that no prejudice would be caused to the respondent if the petitioner is permitted to cross-examine is permitted to cross-examine the respondent. He submits that though they are filing several petitions to expedite the hearing, but they are not cooperating with the court. Then counsel appearing for the respondent submits that only with an intention to protract the proceedings, these kind of petitions are filed. He placed before this court the orders passed by this court on 12th of July 2024 and 25th of September 2024. Referring to 12th July, he submits that this court had directed the trial court to expedite the matter and to dispose of it within a period of 6 months. Then another order came to be passed on 25th September 2024. Again, 24, wherein the petition filed by the wife
Please, ma'am.
is dismissed by the court. That is carried in, what is
No, no, my lords. The amount, my lords, the RPFC which came to be passed by this honorable court, which was dismissed by this honorable court, came to be challenged before the Supreme Court. There, my lords, they dictate that it is arising, that has a bearing on the MC petition. Let the MC be decided at the earliest.
Then in another petition, which is filed arising out of an RPFC, which the matter was carried by the petitioner herein to the Supreme Court by way of
By the respondent,
SLP
by the respondent herein, my lords. I am the respondent. I took it to the Supreme Court.
when the respondent herein took the matter to the by filing SLP number 4574 4576 of 2025, the Honorable Apex Court had directed the trial court to dispose of the matter within a time frame.
Please, my lord, within a time limit of 2 months.
Has been fixed by within the time frame of what?
2 months, my lord.
Within a period of 2 months.
2 months, please.
It is submitted that in spite of several directions from this court and the Honorable Apex Court, the matter, the case could not be disposed of. Now, the petition is citing the fact that a case is pending before this court, though there is no stay granted by this court. He submits that the application that is filed by the petition herein is devoid of merits and the same has to be dismissed. Next para. Having heard the
There in the petition, it was considered from the South. There the other side has suppressed and decided to the South court, stating that in this court and RPFC 28153 for the enhance the maintenance amount from 6,000 to 3,005 and the 3,000 to 3,000 from 3,000 to 5,000 child. So in his petition, he has stated and against before the Honorable Court that this Honorable Court passed only the order of enhancement to the date of orders. May kindly be.
we will not consider what he says. That court will look at the order and understand it.
Also, we have more in almost in order to vacate that orders.
Yes.
Second,
Yes.
they have been decided this Honorable Court in order to
Yes,
obtain
the agreed by the having heard the counsels on either side, peruse the material on record. This court has perused earlier orders where this court had directed the matters to be disposed of within 6 months, and also there is an order of the Honorable Apex Court. Coming to the order impugned, the petitioner wants to cross-examine PW1 in respect of a DNA report that was made before, that was placed before the court in the year 2022. The only reason that is stated is, as on that day, the counsel who was appearing was not in a position to cross-examine, has not filed his objections in the rush of the work. As such, now the present counsel wants to cross-examine PW1. This matter, MCs of the year 2019, DNA report of the year 2022. Every time a new counsel comes on record, that cannot be a ground for the court to go back and again recall a witness for further cross-examination. When the petitioner, when the petitioner is represented by an advocate, and when they have not chosen to file any objections or not to the DNA report, nor they have done anything with regard to the said report, now it is not open for them to recall PW1 on the ground that the new counsel wants to cross-examine PW1.
The husband has argued against the wife with regard to intimacy within one Jagdishas. And that Jagdish has not been examined.
The courts will not wait for the client till he changes counsels, and whenever the counsel is changed, the applications cannot be entertained, and the litigant has to be vigilant within the time frame that is granted by the court to pursue their matter. And in this manner, whenever an advocate is changed, if the court starts recalling its orders or recalling the witnesses, there is no end to the litigation. Strictly within the time frame as fixed by the Honorable Apex Court, the trial court has to dispose of the matter without seeking for any further time. Accordingly dismissed. Every day it has to be.
Absolutely not, my lords. They filed another application 2 weeks ago seeking further evidence of, my lords, the.
Court knows what to do.
Obliged.
Trial court.
Obliged.
ಟ್ವೆಂಟಿ ಅಟೆಂಡ್ ಆಗಿದೆ 1/3. ಇದು ಒಂದು ಡೇಟ್ ಮಾಡ್ತೀನಪ್ಪ ಟ್ಯಾಲಿ ಮಾಡ್ತೀನಿ ದಾದ ತಗೊಳ್ಳು